Any mention?
Please, Your Lordship, I'm praying for a matter to be listed tomorrow. Some urgencies.
What's the matter about?
Lordship is regarding the tender process which has been issued by the state government in respect of supply of food grains in these Agawandi centers. Now the conditions is made in such a manner that it has deprived other bidders to participate. I'm one of the...
Are you existing supplier?
No, Lordship.
Then?
Not existing. There's no concern.
What is your grievance?
My grievance is that the conditions in which the express EOI has been stipulated,
when
that
was
is
it issued,
in direct
EOI?
provision of the National Food
When was it
Security
issued?
Act. Lordship, the last date is on 8th.
When was the EOI issued?
Lordship, the EOI was published on 18 August.
Then now it's already 31st.
Lordship, we just recently came to learn about the
Tomorrow, Monday.
Lordship.
What's the urgency for tomorrow?
Because on 8th, Lordship,
Tomorrow's only the 1st.
Lordship, considering on 7 and 8 is a holiday, so on
Court's opening on 4th.
tomorrow, Lordship, my humble prayer. So
If you can't make a case for urgency, we'll yes anyway.
Lordship. Yes.
May I please, Your Lordship? Your Lordship, I beg to mention item number 26, Your Lordship.
Yes.
We have filed our additional affidavit, Your Lordship, and I prayed for 2 weeks' time, Your
Who's
Lordship.
for the side? You're there.
Petitioner.
You're there for the petitioner.
Yes.
You received the affidavit. I don't understand it. 2 weeks. What affidavit is filed?
Additional affidavit, Your Lordship.
For what?
Certain documents to be submitted before, Your Lordship.
Yes. Yes.
Please, Your Lordship, I beg to make a mention of item number 29. Learned Senior Counsel is indisposed, my lord.
Mr. Siddiqui,
Yes, my lord. I am praying that the matter may be taken up after 2 weeks.
you've taken the consent on the side.
I cannot find them, my lord.
You inform them.
All right, my lord. All right.
The counsel is indisposed. Matter this is a matter for 2 weeks. Yes.
Highly obliged, my lord.
Lordship, I beg to mention item number 28, Lordship. 2 weeks' time may be given, Lordship.
20.
28.
Bina Roy Sangma.
Yes, Lordship. No objection, Lordship.
2 weeks. Yes.
Highly obliged.
Your Lordship, I beg to mention item number 20 on behalf of Mr. M. Chanda.
M. Chanda.
Yes, Lordship.
No objection, Your Lordship.
1 week is 21 matter. Yes.
Lord, I think 20 would become connected to I think 21, 22, 23, and also item 7. My lord.
Then, where was the Chanda? 20 is connected to 21. 22.
21 to 23, and also item 7. My lord. These are again relating to this clerical pay, my lord. I am told that, my lord, this Balbir Singh judgment, my lord, SLB has been filed as of now, but then the details I am awaiting, my lord. My lord, will
After?
After 2 weeks, my lord.
Okay, 2 weeks as prayed. This will affect number 7 also. 7? Yes. 7. Then 20, 21, 20, 23. Yes.
Supplementary list item number 1. May I please, Your Lordship? Your Lordship, this is in regards to issuance of legal license and no objections issued granted by the headman Wehesnong of Limpulit village which is under the Dorbar Ilaka, Narpu, Your Lordship, East Jaintia Hills district, Your Lordship. What happened is that, Your Lordship, in spite of the fact that the respondents fully received the information from the Dorbar Ilaka Narpu, which is in page 18, Your Lordship, annexure number 1, that within the Ilaka Narpu, selling of opening of wine stores and issuing no objection by the Dormas Nong was...
Number 1, I can't read it. Number 1, actually 1, type copy is where?
Yeah,
Okay, yes,
I
next
have,
page.
yes, translated
What does it
copy
say?
is there. Your Lordship, they have written to the superintendent, department.
One second. Who are you?
I am one of the residents of this Lumpuling, yes, Lumpuling
You're the
village,
Doloi?
yes.
Are you
No,
the
I'm
Doloi?
not the Doloi.
And who are
I'm not
you?
the Doloi. I'm the member of the village.
Then
Your Lordship.
what objection do you have?
Because objection is that since in that Ilaka and Lumbali village, if wine store is open, it affects me directly, Your Lordship.
How?
Because this wine store is few meters away from my home also, Your Lordship, and moreover having families and children and relatives, and Your Lordship, here if wine store is open in that village, Your Lordship, it is affecting me, Your Lordship.
Like a public interest litigation.
I beg your pardon.
It's a public interest litigation.
It is not public interest.
No, but
here
then you are aggrieved with the granting of NOC.
yes,
for
granting
wine
of
store
for
by your
opening
headman.
one. Yes, Your
By
Lordship.
your headman.
By our headman. This is he is from Lumpulit village. Your
So you
Lordship.
made a complaint to the council.
He has made a complaint here to district, which is in page 39, Your Lordship.
No, but what is the locus? If there's go, you see, granting of permission, there's provisions in the Excise Act itself. You understand? Then that's.
But
I
Your
don't know
Lordship,
whether you are aware of it,
excise,
but then
yes.
like, before that they take the the no objection from the people in the surrounding area also.
But our grievances is that, Your Lordship, here there should be a public hearing also, and he
Where
has
is his public hearing?
which is in page 22, Your Lordship. Page 22, Your Lordship.
It is held on 17 to 22.
Yes, Your Lordship.
Then-
And this public hearing, these are not according to the writ petitioners.
How can you have you want to open your wine store or
No. We objected
interest in
this one,
opening-
being members of
who
the
are you? But then
villages.
if the public hearing's been heard, you see if the
No, Your
provision of
Lordship,
the
what
act
happened
has
is
been
that this public hearing also, without the knowledge of the Dorvestone, and this even the headman has said that he has issued this no objection without the knowledge of the Dorvestone. These things he has himself.
Doloi is not aggrieved. Where's the solution? Where's the solution taken by the Doloi?
He has
by the Darbar
complained to
Narko
even the Doloi executive on 12 October 2022, which is in page 33, had called the headman why he has issued the no objection certificate to respondent number 6, Your Lordship. He has confessed that he has done this. He has done this without the knowledge of the Dorvestone. And some of the members which are giving their signature, they said that they have never attended. Our allegation is that this minutes of this public hearing is also manufactured by the respondent number 5, Your Lordship. So, Your Lordship, when the
See the annexure 6 is written in Khasi, but the other wine stores there also. See the last paragraph 5. It's not that case is not an isolated case. The dollar is not taken up, or who are you to take it up?
Your Lordship, this was objected by the Doloy also and the Doloy Dorbar Ilaka Narco also, which they have clearly stated before the Superintendent of Excise also that no liquor shop, wine store should be open within the Ilaka, and because this Lumpalit is under the
Whatever it is,
Liquor Narco,
Ms.
Your
Kante,
Lordship.
the thing is that your locus also, why you were just a villager, and as per the records, the public hearing was held, and in other parts in the same Ilaka, there are many wine stores.
No, there is no wine store.
See,
Your
that,
Lordship,
see,
because
it
Your
says by
Lordship,
page
this
12,
wine store in Your
page
Lordship,
annexure 6, it
Because-
says that you can read Khasi, right? See 5. You have not translated this copy, but and the translation is there are 5 paragraph translations, 2 paragraphs. Who translated this?
we have this one in page 19, Your Lordship.
32. See page 32 and 33. Is it a true translation of what 32?
Yes, this is translated.
See, read the translation and read the text.
The decision by the Doloy with the executive.
Is it a true translation of this copy?
This is what they have translated, Your Lordship.
Who has translated?
Yes, the
You can't translate a document to your own convenience. A document is 5 paragraphs, it translates into 2 paragraphs. Who's asked for MS Lingua, come here. Oh, non-country. Show them page 32. Mr. Orhan, see page 32 and see the translation page 33. Whether it's a true translation or not.
This one. This is Khasi. This is different, Lordship. 2 paragraph and 5 paragraph. And here, Lordship, another aspect. The order was passed in February 2021, Lordship. July 2021. And after 2.5 years.
No, even they have no locus.
And no locus.
no, Your Lordship, because
Translate.
You're saying that the Doloy had objection. This is the only document regarding Doloy of annex. Next is correct.
Your Lordship,
See para 5.
yes,
Where was the para 5 find place here in the translation? Who translated this from your office? You tell them translate properly?
Lordship, paragraph 3, 4 and 5 is missing.
Missing.
And paragraph 2 has been split into 2 paragraphs.
but this, Your Lordship, the opening of the wine store, which
We're
was
not taking a petition. If you haven't translated properly, I'm sorry, Mr. Counsel, you're a seasoned lawyer also. Producer material show that the translated copy.
Your Lordship, can I withdraw this one so that I can?
Permitted to withdraw to file afresh.
Yes, Your
if so
Lordship.
advised.
Yes, I'll do that.
Hello.
Make sure that at least
Yes, Your Lordship. Because
suppose I was not aware of the language.
Yes, Your Lordship.
Then I'll go by translation.
Yes,
What will
Your
happen?
I may be allowed to withdraw, Your Lordship. I do apologize. Item number 2.
What happened in the meeting yesterday?
Proposals have been given, Blood, and we were informed, I think.
Accepted.
No, this was not accepted. This is going to be placed before the government. It'll take a really long time. There are 4 different proposals that were given to us. But we were very clear right from the start that the hearing should go on. It should not be stalled in any year.
Yes. Well, this is from you, from your side, and from their side.
Well, it's mentioned the first proposal. From their side, this is the first proposal. In the meeting dated 28/2/2023, it was suggested by so-and-so that the flat parcel of land at Swastik area, approximately 3,000 square feet, after demolition, will be given to the tenants for constructing temporary structures until completion of the building, and upon completion, the tenants will be shifted back to the newly constructed premises. These are some issues, fellows, which we flagged that there may be some difficulties in this, and therefore we gave these 4 different proposals, which we said that whatever you feel appropriate, you may consider.
This comes in the realm of disputed facts now. This court
Precisely.
can't-
And moreover, there was a submission made at the bar yesterday that the MD had invited him for a meeting. That's absolutely incorrect. They went there voluntarily with these offers.
No, we have got a letter.
The letter was for a meeting on
Forget about
Monday.
that. Those are inconsequential.
There was also submissions made that we were never called. This, my lords, as my learned friend for the MDCs pointed out, let this procedure go on. Your lordships may hear us on this main matter and dispose of it.
Yes. Yes, what do you have to say?
Well,
My lord,
matters first.
item number 2, there's only one petitioner, my lord.
Yes.
And well, at the outset, if it pleases your lordship, may I take your lordship to the impugned order? That is at Annexure 7, page 25. Whereas I, the undersigned, after due issuance of show cause notice, am satisfied that Sri Malcolm Ward is in authorized, I think it should be unauthorized, I have some sort of mistake there, occupation of the public premises specified in the schedule below. Now therefore, in exercise of the powers conferred under subsection 1 of section 4 of the Public Premises Act, I, for reasons stated hereunder, hereby order that the said Sri so-and-so and all persons who may be in occupation of the said premises or any part to vacate the said premises within 15 days of the date of service of this order. In the event of the refusal or failure to comply with this order within 11th August 2023, and all other persons concerned shall be liable to be evicted from the said premises if the need be, by use of such force as may be reasonably necessary. That is all, my lord. Now, the order says for reasons stated hereunder, but there is no reason given. And this is the order which was served upon us without anything else. The first service was of this only, my lord. Now, my lord.
Yes.
My lord. So, my lord, this is what we assailed by filing the petition before your lordships. And thereafter, my lord, after we had filed the petition, thereafter an order was affixed on the door of the tenancy premises, some sort of that we have brought by an additional affidavit. No, my lord, because this has been first served upon us, so we are aggrieved by this, and we have said, and this is the effective order, my lord, which effective notice which says that they are liable to be forcibly evicted. Now, my lord, at the very outset, I submit that the other order which has been submitted, my lord, which has been fixed on the door, my lord, that is an afterthought. After the order was made, my lord. Now, my lord, here, my lord, ex facie, this notice shows that only the name of the noticee has been filled up in a blank space, indicating that this is the same order which has been passed for all the notices. So that also indicates there is absolutely no application of mind, my lord. Absolutely no application of mind. Now, my lord, here, my lord, in my respectful submission, my lord, this is either a judicial proceeding or a quasi-judicial proceeding, whichever way we see, my lord, but there is a provision for adducement of evidence. That means, my lord, the Evidence Act comes into play. My lord, the Act might be silent on that, the Public Premises Act, but the provisions of the Evidence Act clearly would apply in any proceedings where the evidences are taken. And there, my lord, the question of burden of proof comes. Burden of proof cannot be shifted by simply reading the letters of a statutory provision. The whole provision of the Evidence Act cannot be ignored just like that, my lord. That is the stand which has been taken in the affidavit in opposition which has been filed, that because this says that giving an opportunity to us to show cause and to produce whatever evidence we have, so that has been complied with, so that the provisions of Section 4 has been complied with. In my humble and respectful submission, my lord, this cannot be entertained, my lord. When provision of evidence is there, the provisions of Evidence Act has to come where evidence is to be led by the person who has instituted the proceedings, and thereafter the evidence of the defense is to be taken into consideration. Now, my lord, firstly, it is a non-speaking order, absolutely non-speaking, no reasons given, and...
You mean the order pasted on the wall?
That was on the subsequent day, my lord. After that was subsequently, my lord.
No, but this notice is a standard notice. I mean, that you've come against the MP notice. The standard notice is under which form?
Form B.
Okay.
So the notice...
It's just like we can just take some substance notice, whatever it's very unhappy the way they've typed it also. But then we'll overlook that. We'll just see the notice under Form B. Correct? That means under Section 4 of...
Section 4. But, my lord, under Section 4, speaking order is a must, and evidence is a must. All that has not been taken. My lord, by the previous annexure, if your lordship will find, by annexure 7, an order was passed, my lord, permitting us to produce our evidences and then, my lord, by way of affidavit. So that was done. Now, my lord, here it cannot be that only the defendants would be required to file there. That would violate the provisions of the Evidence Act grossly, my lord. The sequence of evidence which is laid down in the Evidence Act. So, my lord, that becomes a gross violation of the basic tenets of natural justice and my lord, also of the fundamental rights, statutory laws, my lord. So these are this notice, my lord, therefore it suffers from gross defects, my lord. Now, my lord, the point which has been raised by them is that there is a provision of appeal under Section 8 of the Act. So why did we not go under that provision but approach your lordships here directly? Now, my lord, that is a statutory provision. A statutory law cannot take away your lordship's jurisdictions under 226. That is well settled, my lord. Under 226, jurisdiction cannot be taken out. Now, my lord, what are the parameters to be taken into consideration in exercise of your lordship's jurisdiction under 226? That is of greater importance, greater significance here, my lord. So here, in my humble submission, my lord, whether that provision of appeal is an equally efficacious alternative remedy or not, my lord, where a speaking order has not been given, where grossly violated all tenets of law, my lord, a notice has been served first, subsequently they came and, my lord, complete violation of all tenets of law, my lord. So, in these circumstances, going to a prescribed appellate authority would not be an equally efficacious alternative remedy, in my humble and respectful.
Okay, Mr. Chakravarti, we can condense your challenges to the illegality of this order, like natural justice or procedural legalities, whatever, which cannot be corrected by a regular appeal. The alternate remedies is present. That stares you in the face, right? Only thing you have to satisfy this court that the action of the respondents is such that it warrants interference by excess of powers 226. That's only limited aspect. That's only thing. And so if you can what you call logically, 3 or 4 points on which you are you're raising objections as to why this court should invoke, why you're seeking invocation of 226. That's the only thing.
But
that's only if you look at, because if you cannot satisfy this court on that point, that by appeal these things cannot be satisfied, then maybe there might be a limited interference. But otherwise, no.
So, my lord, in this gross violation of every known premises of law, my lord, when an order has been passed, and even that other order which was effect on a subsequent date, my lord, that order also does not address our case as made out in our show cause. My lord, we have placed it before your lordship also here, my lord. We, in our show cause, my lord, we have pointed out that this shop room, which is in our occupation, I think this is our case, and maybe one or two others could be having identical case.
You argue your own case. Let them argue their case.
Our case is that we were given the plot of land, and we spent our money, and we constructed the building, my lord. On all that, they are absolutely silent. They are dealing with us just as another tenant of their premises.
You mean to say that this building this shop was constructed by you?
My lord, that is our show cause, and that aspect has not been granted any consideration at all, neither in this notice which has been served, nor in the speaking order which has been served subsequently on us, my lord. Our case, complete non-application of mine, my lord.
You filed your affidavit. You filed your evidence.
My lord,
been filed.
Evidence filed, show cause filed, no reference at all to all that.
In that order dated 24th.
Well, 24th also, and that what has been affixed on the yes, that is 24th. Yes. That also there is no reference. In this notice also no reference. That means our case has not been given the least consideration, my lord.
Mm-hmm.
How much more gross injustice can be there, my lord?
Yes.
So, in my very humble submission, my lord, that this is a clear case for your lordships to intervene, my lord. That aspect, that alternative remedy is there, or statutory provision of appeal is there, my lord, this would not come in the way of exercising jurisdiction by your lordships. So, this is our case. These are the facts of the case. As far as law is concerned, my lord, these are two aspects only. One is that whether your lordship can exercise, is prevented from exercising.
No prevention. It's like self-restraint.
Like parameters.
Parameters. Self-restraint. Whether you should exercise the discretion to interfere. If a very overwhelming case not made out. That's all.
So, in my humble and respectful submission, this is a fit case where your lordships will exercise the jurisdiction, set aside this matter.
You mean it's blatant violation of principle of
blatant justice of every aspect. So, this may be sent back then to them, my lord, for procedure to be followed, and that is a different aspect. That is in your lordship's discretion, my lord. Otherwise, this is a blatant.
Okay.
So, these are the facts and these are the basic things. Otherwise, I do not have much more submissions, my lord. All that is there in the pleadings and all that, the grounds also have been taken. All are there, my lord. So, I rest my case, my lord.
Yes, Mr.
Wishing your lordship. All right.
Yes, thank you. Yes.
May please, Your Lordships. My lords, we've prepared a list of dates of how this matter has transpired. List of dates. Now, what has happened, my lords, is lordships would have seen. I'll start from 21 to 2022, my lords. where there was this first notice under Section 3 of the PP Act that was issued to us.
Okay.
Thereafter, my lords, we filed a show cause before the Deputy Commissioner, my lords, on 2/9/2022. And my lords, on 23/12/2022, we received another notice, my lords, that the matter relating to had been rescheduled and petitioners to appear in person along with the relevant documents, evidences on 9/1/2023. 9/1/2023, my lords, we appeared before the Deputy Commissioner. For my lords, before that, my lords, if I may first take your lordships to the initial notice issued under Section 3, my lords, at page 29. If your lordships kindly have that.
Page 29.
29, my lords, 29.
One second.
This is WPC.
Yes.
Ballots.
This is 21st February 2022.
Ballots.
Yes.
If I may read the notice, my lords, so this is to so-and-so, whereas I, the undersigned, am of the opinion that you are in unauthorized occupation of the public premises mentioned in the schedule below, and that for the grounds stated hereunder, you should be evicted from the said premises. Now, what are the grounds, my lords? You are found to have entered into a tenancy agreement dated 1/4/2016 as an occupant of room number so-and-so, ground floor of Meghalaya Transport Corporation for a period of 5 years, which is expired on the 31st of March 2021. Notice has been issued to you by letter dated so-and-so by the Managing Director so-and-so to vacate the premises and hand over the vacant possession within a period of 60 days from the date of receiving this notice on account of expiry of the agreement and due to the corporation's urgent and bona fide need of the premises. I would crave your lordship's indulgence to kindly take note of this expression, my lords. So the eviction was sought, my lords, primarily on two grounds. One is termination of the tenancy, my lords. Two was bona fide and urgent need of the corporation.
Yes.
So, my lords, I had taken your lordships to 9/1/2023, my lords, when the matter was fixed. So we appeared and we pointed out that the law as it relates as on today is,
Yes.
my lords, that the MTC has to first lead evidence. We have to be given an opportunity of cross-examining the case of MTC, and thereafter the matter would follow for our evidence. To that extent, my lords, an order was passed by the Deputy Commissioner on the on 10/1/2023. Your lordships would find that at page 30.
Okay. Yes.
If your lordships kindly have page 30, my lords.
Yes.
May I read this order, my lords? This is dated 10/1/2023. Seen applications filed by the occupants, tenants praying that the landlord MTC adduce evidence first. The counsel for MTC has agreed to lead evidence without any further delay in these proceedings. The MTC shall file evidences of its witnesses by way of an affidavit of all the cases on or before 17/1/2023, along with documents, and provide copies of the affidavits and the documents to the counsel for the occupants' tenants. The date for cross-examination of the MTC's witness shall be communicated to the parties, on which date the tenant shall cross-examine the MTC witnesses. On the suggestion and agreement of both the parties, my lords, these three issues were framed. So, your lordships, the two aspects: one, the Deputy Commissioner says MTC to lead evidence; two, MTC says, my lords, that yes, we will lead evidence. Thereafter, my lords, the matter then came up for consideration before the Deputy Commissioner on 8/6/2023. And, my lords, on 8/6/2023, your lordships would find that order at page 31. The matter has been fixed for appearance of MTC and the tenants. MTC is represented by Mr. So-and-so and the tenants are represented by the councils. It is seen that notice has been served of 44 out of the 48 tenants. The other tenants have not been found, and as such notice could not be served on them. Notice be reissued on the other tenants at an alternative address or by contacting them over phone. As per the order dated 10/1/2023, issues have been framed and it was directed that MTC shall file its evidence by affidavit. The same has not been filed, and the counsel for MTC has explained today that MTC does not want to file any affidavit to establish bona fide requirement of the premises, as MTC has requested eviction on the ground of expiry of the tenancy agreement. The counsel for the tenants raised objection to the submission and requested district magistrate to withdraw the notice of eviction. In response, the counsel for MTC submits that it has moved for eviction on the ground of expiry of tenancy agreement, and the tenants are at liberty to file affidavit objecting to the same on the next date fixed. The tenants are directed to file their evidences and affidavit on so-and-so in the Deputy Commissioner positively, and the MTC shall cross-examine the tenants thereafter. Now, thereafter, we had sought time from the Deputy Commissioner insofar as the evidence part of it was concerned. That we had said that we'll need some time to comply with the orders of 8/6/2023. Now, that was not done, my lords. We had also filed an appeal against this particular order. That matter is, while that matter was pending before the appellate forum, my lords,
what's happened there?
My lords, now the Revenue Board has taken a view that since the final order has been passed in these, so the appeals have become infructuous in spite of the first order of 9/8/2023 being produced before the Revenue Board, my lords. They have dismissed my appeals. We have pointed out that your lordships are seized of the matter. Unfortunately, my lords, but that will come in an independent proceeding. So, be that as it may. The position is, my lords, we did not file the evidence. We filed an application before the Deputy Commissioner saying, we have filed an appeal, so you kindly keep these proceedings in abeyance. We are then met with the order, my lords, at Form B at page 32. Now, before I take your lordships to, my lords, the contents of 32, if I may first take your lordships through the rules. The Meghalaya public premises. Rules. We have extra copies. Give it to the court master. Your lordships have it, my lords. Well, as I draw your lordship's attention to Rule 3.
Rules. Very good. Yes.
Well, it's forms, notices and orders. Your lordships have it, my lords.
Right.
A notice or order under Act, it should be read, my lords, under the Act, shall be in one of the appropriate forms appended to these rules. Now, under these rules, my lords, your lordships will then come to Form B. Now, your lordships would kindly see, my lords, Form B, order under subsection 1 of section 4 of the Meghalaya Public Premises Eviction of Unauthorized Occupants Act 1980, read with Rule 3.
Yes.
Whereas I, the undersigned, after due consideration of the show cause. Now, this is something, my lords, which even I had missed. And when the matter was initially being moved, my lords, your lordships have pointed this out. Now, this is the format of that particular notice, my lords. So, what it says is, to my understanding, that the consideration has to be of the show cause, my lords.
Yes.
And the evidence tendered.
Yes.
And, my lords, on that basis, the Deputy Commissioner can form an opinion that either I am in authorized possession or I am in unauthorized possession.
You have tendered the evidence, but you have not tendered the evidence.
No, my lords, we had sought time for tendering evidence. And, my lords, would kindly see down below is schedule, and below schedule, your lordships will see reasons. So it has to be a reasoned order. Now, why I pointed out Rule 3 is, my lords, that an order under the Act essentially has to be passed in Form B.
Yes.
Here what has happened is, my lords, the original order of 28/7/2023 was indeed passed in Form B. But somebody realized, my lords, in the way that probably this order will not hold. So what they do is they go back and pass an order, my lords, which is a 6-page order, and I'll deal with that order also, and trying to cover up the flaws in this particular order. Now, I will take your lordships to the order that we were talking about, my lords, page 32. Your lordships have it, my lord.
Yes.
Now, how this reads, my lords, is very interesting. Whereas I, the undersigned, after due issuance of show cause notice. Your lordships, there's a stark difference which even I had missed. There it says consideration of the show cause, here it says issuance of the show cause. So, what essentially the Deputy Commissioner here is trying to say in these proceedings is, I have issued a show cause notice and satisfied that so and so is or in authorizes occupation, my lords, of the public premises so and so, now in exercise of powers under so and so, schedule given. Where are the reasons why I am not in authorized occupation?
Yes.
Now, the other very interesting thing your lordships will kindly note is the memo number under which this notice has been issued.
Yes.
My lords, the memo number will be, it's 48. Lordships have seen
same memo number for all people.
it is essentially a same memo number for all the 30 petitioners before your lordships, even though the initial notice under section 3 was issued under separate memo numbers.
Yes.
So essentially, my lords, nothing was done. Somebody sat down, decided to take a piece of paper, cyclostyle it, my lords, or photocopy it, and then fill in names with the hand. And to the extent your lordships would see, it is signed by the Deputy Commissioner of a district. The Deputy Commissioner, my lords, does not understand the difference between authorizers and unauthorized. Consideration of show cause or issuance of show cause notice. So absolutely, my lords, there was no application of mind, which is where, my lords, somebody in the...
Whoever typed this notice is absolutely uninstructed. Even spelling of days is wrong and not corrected at
Your
all.
lordships would have seen the I appears twice. Whereas I, comma, I.
Yes.
And my lords, I'm sure, my lords, the Deputy Commissioner is not hard of sight that this notice was signed by her even while these blatant anomalies were there.
Yes.
So, my lords, this establishes that this was signed absolutely without any application of mind. So, my first limb of my submission is, my lords, that this particular notice is the notice statutorily prescribed under which an order under section 4 is to be passed. It cannot be otherwise.
Can't it be a gist of the decision of the reasons?
I'm sorry, my
be
lords.
given in the form, because in a form, order might follow, a form might follow an order, but then...
My lords,
can't it
which
be
is what
just-
I had submitted.
Yes.
It is not an order which is followed up by this particular notice. That communication of the gist of the order be followed up by a particular prescribed notice.
yes.
Why I say that, my lords, I'll again take your lordships back to rule 3.
Yes.
It says, my lords, a notice or order. So the statute has made it clear, my lords, it's not only a notice or order, shall be in one of the appropriate forms appended to these rules. So the order has to be in this form.
Right, okay.
So, my lords, somebody in the hierarchy then realized that this probably will not hold water. So, my lords, then on 8th of August 2023, at 9 o'clock at night, somebody comes and pastes a copy of, my lords, a purported order passed on 24th in the main premises of MTC. And, my lords, I will take your lordships to that order. Page 62.
Yes.
Now this order is again, my lords, very interestingly drafted or written. Your lordships will kindly see, it starts with proceedings under section 3 and 4 of the Meghalaya Public Premises Eviction of Unauthorized Occupants Act 1980. By this common judgment on order, I shall be passing the order on the application filed by MTC under Public Premises Act 1980. Where is the application? First question I ask myself, my lords, where is the application?
Okay, yes.
Facts in a nutshell is that MTC, Government of Meghalaya Undertaking Police Bazaar, filed the petition under section 3 of the Meghalaya Public Premises Act against the persons, tenants unauthorizedly occupying MTC building at Police Bazaar, Shillong. Well, if I may pause here for a second and take your lordships to section 3
of the Act.
My lords. In the Act. No, I have it here. I have it. The lordships have it.
Yes.
If the Deputy Commissioner is of the opinion, your lordships have found it. If the Deputy Commissioner is of the opinion that any person is an unauthorized occupation of any public premises and that they should be evicted, the Deputy Commissioner shall issue a notice, shall issue in the manner hereinafter provided a notice in writing calling upon the persons concerned to show cause to why eviction should not be made. The notice shall specify so and so. What I'm harping at is, my lords, the Deputy Commissioner notes that they filed a petition. Which petition? If there is a petition, my lords, I have to be served with a copy of a petition. There cannot be a petition in a proceeding under the PP Act. Fundamental non-application of mind. The Deputy Commissioner who's dealing with the issue, my lords, does not even know whether there is a proceeding under the PP Act, whether she is dealing with a civil suit, whether some applications have been filed, not filed.
Was an application filed for disposing of by common judgment?
No.
What is the
I think my
application?
friend is on a wrong footing. Whenever a authority finds that somebody is in unauthorized occupation, they write to the DC to
That's
initiate
a
proceedings.
requisition,
That is
my
what they're
lords.
talking about.
Okay, anyway. So
That is what they're referring
let
to.
him continue.
My lords, that is a requisition. I am not entitled to that copy of that requisition, which is an internal communication between the Deputy Commissioner and the concerned department.
Yes. Let me continue.
It was stated that the petition of the corporation, it was stated in the petition, my lords. Your lordships will kindly see. So there is a petition, my lords. I don't have a copy of that petition till today.
Yes.
It is stated in the petition that the corporation entered into a tenancy agreement unregistered with the tenant for a period of so and so. The further case of the corporation is that the tenant's agreement has come to an end with efflux of time. The corporation has further stated that the notice of eviction to the tenant's occupants were duly served, and despite notice, the tenant's unauthorized occupants are not in vacating the public premises at Police Bazaar. A common show cause notice order herein in Form A was issued by the undersigned on the applicant's corporation. My lords, it was not a common show cause notice. Courtmaster, if you could kindly just.
Not annexed here.
My lords, we had annexed one because there was paucity of time at that point of time, my lords, and I did not want to seek more time from your lordships on this. The memo number your lordships will kindly see down below. I've highlighted it.
Yes.
The first, my lords, the document which is annexed before your lordships at the initial thing, my lords, at
Moshumi Chanda.
page 29, your lordship would see that is serial number, memo number 29. The last, at page 29, my lords, it is 29.
Yes.
And, my lords, the other notices which I've placed before your lordships, my lords, all of them bear a different number. These are copies, my lords?
Yes, okay, yeah, take them back.
So, my lords, I was there.
Yes.
A common show cause notice order was issued by the undersigned on the applicants of the corporation to the tenants and occupants by notice dated 21/2/2022 directing the tenants unauthorized occupants to vacate the premises and hand over peaceful possession within 60 days to the corporation. A show cause notice was issued as to why eviction order be not passed under subsection 3 of subsection 1 of section 3 of the Meghalaya Public Premises Unauthorized Occupants Act 1980, and the time was given to supply reply on or before 7/3/2022. In some cases, notices were issued on so-and-so, giving time to the notices to be show cause. It has been brought on record that the tenants, unauthorized occupants, entered some sort of negotiations with the corporation, but the same failed. Some of the notices filed the reply to the show cause stating that they have been paying enhanced rent after the period of tenancy and they continue to deposit the same even in civil court. It was stated that the relationship of the corporation of noticee is governed by the Urban Areas Rent Control Act and Meghalaya Public Premises Act is not applicable. It is also stated that some of the notices have approached civil court against eviction notices. The proceedings under the Act came up for further hearing before the undersigned on 10/1/2023 and the following issues were framed for determination. Whether pendency of a civil suit filed by the tenants can prevent continuation of the PPA proceedings, whether there is perpetual tenancy between the landlord and the tenants, whether the tenants are an unauthorized occupation under the PPA Act. The case was listed for hearing time to time, and finally the case came up for hearing on 8/6/2023. It was noted that the notice has been served on 44 or 48 tenants. The remaining tenants were also served. Further opportunity was given to lead evidence, if any. It was duly noted in the order dated 8/6/2023 that the corporation is confining its case of eviction on the ground of the tenancy has expired with efflux of time. Well, I fail to understand where was this there. Anyway, I've taken your lordship to that order of 8/6/2023. On the other hand, counsel for the tenants requested the deputy commissioner to withdraw a notice of eviction. Further opportunity was given to the tenants to file affidavit objecting to the ground of eviction is being sought by the corporation and the tenants on the ground the tenancy agreement has come to an end with efflux of time and occupation of the tenants of the premises. The tenancy agreement has come to an end is illegal. The matter was kept for further hearing on 14/6/2023. The matter came up for hearing on 5/7/2023 and the undersigned was informed that the tenants have preferred an appeal and the order of the undersigned dated 8/6/2023. Finally, the case was put up for hearing and order on 24/7/2023. I have gone through the relevant records and I have also taken into consideration the contention and contentions raised by the tenants occupants of the MTC. Well, she reiterates section 2. I will come to paragraph 12, Millets.
Yes.
It is a matter of record that tenancy agreement in respect of the public premises has come to an end with efflux of time. The fact that tenancy agreement has come to an end has not been disputed. My lords, it is specifically disputed in the show cause.
Yes.
Which is why, my lords, that issue number 2 is been framed, whether the tenancy is perpetual or not. Therefore, the continuance or occupation of the public premises in question and after the coming
has not been placed on record, my lord. The petitioner has not placed so cause on record. Now
the MTC has. Before you interject, please have your records. MTC has.
Yes, continue.
Therefore, the continuance or occupation of the public premises in question after the coming to an end of the term of tenancy is nothing but unauthorized occupation within the meaning of section 2. Now, coming to the issues framed on 10/1/2023, I am of the considered view that a notice have no case to support their claim. As far the issue of pendency of civil suit is concerned, the challenge was laid to the noticee Sheila Margaret Suiting Millers, whatever. Your lordship's order, the Honourable High Court by judgment on order dated so-and-so passed in the above writ petition in unequivocal terms held that the MTC is not precluded from resorting to Public Premises Act for recovery of suit premises. And my lords, the operative portion of the order of your lordships is, my lords, then reproduced. However, before parting with the records, though the respondent is not precluded from resorting to the Public Premises Act for recovery of possession of the suit premises, taking into account that civil proceedings are pending where interim orders are operating, all further actions by the respondents are to be in accordance and with the due process of law. So, your lordships have dealt with this issue, my lords, and your lordships have made an indication saying that there is some civil proceedings pending. Any proceeding under the PPA Act, my lords, would have to be essentially under following the due process of law. Therefore, in view of the categorical pronouncement of the Honourable High Court, the notices cannot prolong the proceedings under so-and-so. The issue number 1 is decided in favour of the corporation and against the notices. Now, 15. There is no merit so far as the contention relating to perpetual tenancy is concerned. As a matter of fact, that the tenancy agreement was for a definitive period of time, more so since the tenancy agreements are unregistered, at best the agreements are in the nature of man-to-man tenancy. On this count also, the notices fail to make out any case of perpetual tenancy. As far as issue number 3 is concerned, the same has been dealt in detail in foregoing paragraphs number so-and-so. Last but not the least, The plea that appeal has been preferred against the order of the undersigned directing the notices to file evidence, as therefore the proceedings are to be kept in abeyance, have no merit. It is a dilatory tactics on the part of the notices. A bare perusal of section 8 of so-and-so shows that the appeal shall lie from every order of the Deputy Commissioner in respect of the public premises under section 4 or section 6 of to the Board of Revenue. The order of the undersigned dated 14/6/2023, it should not be 14/6, it should be 8/6, is not an order under section 4 of the Meghalaya Public Premises Act 1980. So the order by which I am directed to file evidence is not even an order under the PP Act.
Okay.
On this count also the proceedings cannot be delayed any further. The occupants are unauthorizedly occupying the public premises, and therefore the occupation of public premises is nothing but unauthorized occupation under section 2 of the Act. I therefore, my lords, this eviction order is passed.
Yes.
Now, this MTC, my lords, even though on the first occasion when the matter came up before your lordships on 9th, my learned friend, the Advocate General, had initially made a statement that they want to file an affidavit. Subsequently, my lords, it was pointed out that it is a quasi-judicial proceeding. They don't want to file an affidavit. Fair enough. The MTC has filed an affidavit, my lords. I will take your lordships to the affidavit filed by MTC. So they have taken a preliminary objection in paragraph 3, my lords, about there being an alternative remedy of appeal available before to me. And as such, my lords, your lordships, this writ petition may not be maintainable in its present form. Now, which is what, my lords, in the earlier matter where my learned senior, my lords, Mr. Chakravarti was appearing, it fell from your lordships, that it is more of a case of self-restraint that is exercised by your lordships, insofar as, my lords, entertaining a writ petition or passing any orders therein. My lords, just show me Whirlpool, please. No?
Whirlpool.
My lords. Whirlpool and, my lords, the plethora of judgments that follow thereafter. Because your lordships have, my lords, essentially, to my humble understanding of the law, this is 1998 8 SCC, page 1. Paragraph 14, my lords. (1998) 1998 8 SCC, page 1. Your lordships have it, my lords. Paragraph 11, paragraph 14 at page 9.
Yes.
The power to issue prerogative writs under Article 226 of the Constitution is plenary in nature, and it is not limited by any other provision of the Constitution. The power can be exercised by the High Court not only for issuing writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari for the enforcement of any fundamental rights contained in Part 3 of the Constitution, but for any other purpose. Under Article 226 of the Constitution, the High Court, having regard to the facts of the case, has a discretion to entertain or not to entertain a writ petition. But the High Court has imposed upon itself certain restrictions, one of which is that an effective and efficacious remedy is available. The High Court would not normally exercise its jurisdiction, but the alternative remedy has been consistently held by this court not to operate as a bar in at least 3 contingencies. Namely, where the writ petition has been filed for enforcement of any fundamental right, or where there has been a violation of the principles of natural justice, or where the order of proceedings are wholly without jurisdiction and the virus of an act is challenged. Here, my lords, your lordships would have seen that even though there is a requirement under the Act to follow a certain procedure, including granting me a reasonable opportunity of being heard, this impugned order, or both the orders, my lords, if I may put it so,
Suffer from.
Admittedly has been passed without hearing anybody. If I have not filed my evidence, my lords, the procedure requires that the evidence be closed. Fair enough. We will hear the matter on whatever is available on record. Not done. I will draw your lordship's attention to section 4 of the main act, my lords.
Yes.
Well, if after considering the cause, if any, shown by the person in pursuance of the notice under section 3, and any evidence that he may produce in support of the same, and after giving him a reasonable opportunity of being heard, the Deputy Commissioner is satisfied that the public premises are in unauthorized occupation of the occupation, the Deputy Commissioner may make an order of eviction. So there are 3 requirements, my lords. You have to consider the show cause. Any evidence that may have been produced by me, my lords, has to be considered. And after giving him a reasonable opportunity of being heard. In all these, in the proceedings before your lordships would see, the order of 28th, my lords, which is in Form B, says that there is no consideration. Assuming, my lords, we go back to 24th, again your lordships would see.
No, firstly, can that notice can be said to be in the Form B at all?
My lords, it is not. That's the first limb of my submission, my lords. I am just on assumptions that assuming it is in Form B and it is the correct order. Then also, my lords, it suffers from this vice. Now, when these vices are, my lords, apparent before your lordships, whether, my lords, I will be relegated to the remedy of appeal.
Okay. Next.
My lords, and here it is very pertinent, my lords. This is, of course, part of the record, but unfortunately, it missed everybody's. Sheila suiting his petitioner number.
Civil proceedings.
No, my lords. This is the second round she's before your lordships. Because earlier also a perpetrated order was passed. And your lordships, when we pointed out the orders, that order was withdrawn by the Deputy Commissioner.
Is in record.
She's petitioner number 24, my lords.
What happened earlier?
My lords, another order, perpetrated order was passed under section 4 for eviction. We came and challenged it before your lordships. There were apparent errors in it. So, my lords, upon instructions, the DC withdrew that order. And in terms of whatever order was passed by your lordships, my lords, it was then decided that the matter be remanded and the procedure under the Act be followed. That was, my lords, WPC number 209 of 2022.
209.
Well, I have a copy of the order. It was disposed of by judgment on order dated 16/6/2022. Do you have another copy?
Yes.
Well, at this stage, I do not really want to go into the merits of whatever is there in the proceedings before the Deputy Commissioner.
You're pointing out the irregularities.
I am simply saying, my lords, that you are required to pass an order. It has to be done expeditiously. But expeditiously does not mean, my lords, you throw everything out of the window. Interestingly, my lords, it is that MTC which is seeking to defend the order of the respondent number 3. Whereas they are also party to the same list.
No, that doesn't matter. Anyway, any other submission?
Well, my humble submission before your lordships is, in the facts of this particular case, my lords, it is but apparent that there was no application of mind by the Deputy Commissioner.
Yes.
I was never heard. Forget me, my lords, MTC was also never heard.
Yes.
And an order came to be passed, my lords, first on 28th. Thereafter, my lords, to cover up 28th, you go back and you show that you passed an order on 9th. And I pointed out in my rejoinder, my lords, after mention of the matter was made before your lordships on 9th of August 2023 at 10:30 a.m. for moving this matter unlisted, we were served with copies of that perpetrated order around 1 o'clock. Rejoinder.
Okay. Yes.
So subject to what they say on law, my lords, I'll respond.
Yes. Who's addressing the court? Yes, Mr. Advocate General.
Lord, I would request Mr. Singh to highlight on facts. I will place the legal position, my lord. What is the legal? Because Mr. Sen has filed. If your lordship, if I have understood the arguments of learned senior Rupis correctly, my lord, there are three arguments. One, my lord, that there is a violation of principle of natural justice. Therefore, your lordship should entertain Article 226, my lord. There is a procedural violation in passing the order, my lord. And third is that that evidence procedural in part of procedural violation. What they are saying that they did not get opportunity to lead the evidence. This is and therefore your lordship should exercise jurisdiction under Article 226. This is a discretionary. Now, order sheet has been placed before your lordship. The order sheet has been placed. I'll take the first case, my lord, of Mr. Chakravarti, Learned Senior Counsel, who argued of Mr. Malcolm, my lord. Kindly see the petition, my lord. Kindly see the reply, so-called reply at page 10 of writ petition filed by Mr. Malcolm Ward. First petition, my lord.
Page 10.
Page 10, my lord.
Yes, page 10.
Page 10 is the so-called, my lord, by the tenant, my lord.
It's annexure, page 10.
Annexure 1, my lord. Annexure 1.
Of the petition?
Of the petition, my lord.
Annexure 1 of Malcolm Ward's petition? Or you from the affidavit or the petition?
I'm sorry, I committed mistake, my lord. Sometimes it happens. If your lordship will see the annexure 1, page 16.
Yes.
Now, page 16 is what is being argued, my lord, is an allotment of open space, my lord.
Yes.
Page 16, my lord.
Yes.
So he was admitted fact is that he is a tenant, my lord, of the premises owned by MTC, my lord. That fact is not denied, my lord.
Yes.
Now, the tenancy has also expired. This fact is also not denied, my lord. I put a question to myself, my lord. If I have to lead the evidence, I have to first plead that I want to show that the tenancy has not expired. Therefore, I want to lead evidence on that point.
Yes.
And therefore, the purpose of leading evidence is to show, because your lordship has seen that MTC issued the so-called by Meghalaya Transport Corporation was on two grounds: bona fide requirement and lead expiring with a flex of time. What has happened, my lord, that so far as bona fide requirement is concerned, your lordship is aware that that ground is required to be stated when your premise is covered by Tenancy Act, Rent Control Act, my lord. Because there are two grounds in Rent Control Act: bona fide requirement and default in payment of rent, if the premises is covered under Rent Control Act. But under Public Premises Eviction Act, the requirement is only that the agreement has come to an end or agreement has been terminated, my lord. So therefore, in my humble submission, in both cases, my lord, petitioners have not even avowed a single line that tenancy has not come to an end. But they are saying that there is a violation of procedure because opportunity to lead evidence was not given. I put a question to myself, my lord, isn't it a case of dilatory practice where the tenant whose term has come to an end, he wants to prolong the proceeding, first either filing the civil suit, then thereafter approaching this honorable court, and then again, my lord, because your lordship has seen civil suit was pending against the same premises, again then they go to come before your lordship clarifies the legal position, gives the right to the DC to proceed in accordance with law. Deputy Commissioner has proceeded in accordance with law in passing the order. Now, I take to the counter affidavit of MTC, my lord, and where so-called has been so-called filed by the petitioner is placed. My lord, I wish to place one important aspect. A counter affidavit in Sanjay case home in the second matter, my lord, filed by Meghalaya Transport Corporation. at page 10. But since, my lord, I have one very important and pertinent submission to make, my lord.
1 second.
The issue is, my lord, before your lordship gets the counter affidavit, my lord.
Yes.
Petitioner is approaching the equity, the jurisdiction under Article 226, my lord, is the jurisdiction of equity, goods, consigns, and clean hand, my lord. I put a question to my lord, why in all cases what I see is that all important documents are suppressed by petitioner, my lord.
What do you mean suppressed?
Because if the petitioner is making out a case against the MTC, his first duty to the court and to the other side is to place his reply of so called. And in my humble submission is that the petitioner has failed in that duty. And on this ground alone, the petition should, because this is suppression. And suppressio veri is suggestio falsi, my lord. That maxim we have been learning in the law colleges. But what I see, my lord, very unfortunate, most of the time they suppress the so-called and the important document and orders also. They will place only those orders and suppress the orders also. I will take your lordship to the so-called, my lord. Kindly, because the evidence is being sought on the basis of this so-called, which is at page 10, my lord.
He said that he's issuing a formal letter. He's accepted the and the contractor was also.
Yes.
In response to the notice under section 3, subsection 1 of Meghalaya Premises Eviction Act 1980, my lord. So notice has been received by the petitioner, my lord. This is the notice which contains the reasons for his eviction, my lord. He says that I didn't receive any petition, anything. What my learned friend said. Read with Rule 3 dated 18th August 2022. Undersigned notice begs the following so called. Now, the first line, my lord, undersigned had entered into tenancy agreement with regard to tenancy premises initially in 1996. So admits that there is a tenancy. Then, my lord, third line of this same paragraph. It is pertinent to mention here that the last agreement was executed on 1st April 2006 and there was a specific clause stating tenancy shall be renewable at the fixed term at the enhanced rate up to be decided from time to time. Now, my lord, this 1/4/2006 tenancy agreement, if your lordship, unfortunately, that tenancy agreement is not again placed by the petitioner, and that is at page 16, my lord. Kindly see the tenancy agreement.
I'm not saying that he said it's second.
Yes.
And the relevant page of the tenancy agreement starts from page 16, my lord. And the relevant page of tenancy agreement is page 18 at paragraph 2, my lord. The tenancy shall begin from the day of handing over the premises to tenant or on such date as premises is already in letting out from 1st April and terminating the last day of such month on 31st April 2021. So the tenancy has come to an end on 31st April 2021 and the occupants who are sitting in the tenanted premises are unauthorized occupant in law, my lord. It has been more than 2 years, my lord. Now they want to lead evidence. And it's not that the deputy commissioner has not given them opportunity to lead evidence under section 3.
Yes.
The opportunity was granted. That very opportunity was challenged by the petitioner because petitioner was aware that he has no case in terms of this agreement. The appeal in the Public Premises Act is only against the order passed under section 4. But the appeal was preferred against the order of the deputy commissioner,
yes,
granting them opportunity to lead evidence because MTC maintained this time that it doesn't want to go into the issue of bona fide requirement because public premises can be evicted even without requirement of bona fide requirement. So the tenants which are before your lordship, their tenancies have expired and they have not placed reply to so-called and tenancy agreement, which would have shown that it's a futile exercise. I would urge your lordship to take into consideration it's a futility theory which is being invoked and applied against the recalcitrant petitioners who wants to take advantage of the legal wrangling, so that they can continue their possession indefinitely. But the time has come where the court has not accepted this kind of technical pleas to defeat the substantive right, because under the smart city, my lord, this building has to be demolished. Fund has come, my lord, to construct the proper building, proper amenities, my lord. And the tenants are, and we have been following the process of law for last 2 years, my lord. Now, in the light of that, my lord, kindly see the so-called notices and everything which has been placed, my lord, at page 29 of the repetition. This is a notice issued and which the receipt of notice is admitted. It's not page 29.
29 or 25?
It's a page, my lord.
Oh no, I have the wrong repetition. Yes.
He's relying on
It's
my
29.
Okay. Yes.
Whereas now, my lord, this notice is given to Sanjay Kumar Sharma. In terms of that, you are found to have entered into a tenancy agreement dated 1/4/2016 as an occupant of room number so and so for a period of 5 years, which expired on 31st March 2021. Notice has been issued to you by number 24th August by the Managing Director, Meghalaya Transport Corporation. So Meghalaya Transport Corporation also issued and hand over the vacant position within 60 days from the date of receiving of the notice on account of expiry of agreement and due to corporation's urgent and bona fide requirement for which you have failed to comply. Therefore, under subsection 1 of the Act, call upon to show cause before 7th March as to why such an order eviction should not be made. And reply, I have placed Lord of show cause. They are saying that yes, tenancy agreement is there, and then thereafter, my lord, kindly see the order, some of the order sheets which have been placed at next page, my lord, of the Deputy Commissioner at page 30.
Yes.
Seen the application filed by the occupant tenants praying that landlord MTC adduce evidence first line of the order, my lord. So what they are saying that we should lead the evidence, my lord. The application is being filed. I am seeking eviction, my lord, and the application is I should lead the evidence. The council member has agreed to lead evidence without any further delay, because MTC shall file the evidence witnesses by way of affidavit on 17 January. The cross-examination on suggestion and agreement both the parties, these issues were framed by the Deputy Commissioner, my lord, which has been read out by my friend. On next page, my lord, at page 31 or 30,
yes,
Annex 3, my lord, 8.6, CR put matter has been fixed for appearance of MTC and tenants. MTC is represented by so and so. It is seen that notice has been served on 44 out of 48 tenants. The other tenants have not been found as such notices because some of them are in dilapidated conditions below. They are not even using that. Notices be issued on the tenant's alternative address. As per the order of 10th January 23, issues have been framed and it was directed that MTC shall file the evidence. But same has not been filed by counsel of MTC. MTC does not want to file evidence. Affidavit to establish bona fide requirement. So what MTC is making the submission before the learned Deputy Commissioner is that they do not want to file the evidence to prove the bona fide. In effect, my lord, in law, they are giving up the ground of bona fide requirement. If I understand this order and the stand of MTC clearly, my lord. Because there is, in my humble submission, according to me, my lord, there is no requirement to go into the bona fide requirement when it comes to public premises. And rightly so, has requested eviction on the ground of expiry of tenancy agreement. So only ground which was asked before the Deputy Commissioner that the lease has come to an end, and that too, my lord, your lordship would take note of the fact that this is all unregistered lease. These terms can't be read into, and it will become at best month-to-month tenancy, my lord. The counsel for the tenant raised objection to his submission. Now they are saying, no, direct the plaintiff to lead evidence. And district is to withdraw the notice of eviction. Response has moved the eviction on the ground of expiry of tenancy and at liberty to file affidavit objecting to the same the next day. So then liberty and opportunity was given to the petitioner, my lord, to say that procedural infirmity is there. With utmost respect, my lord, there is no procedural in all these matters. I have been lawyer from both sides. We have been raising all these kind of grounds, my lord, that there is a, when you don't have law in your favor, you will try to do the nitpicking. Council for the MTC submit that it has moved the eviction on the ground of expiry of tenants, and tenants are liberty to file objections. So they do not file, my lord. And your lordship, kindly take note, this order is challenged in the appeal. What order is challenged? This order is challenged before this interim order, that the opportunity of giving evidence to the petitioner is being challenged. And the grievance which is being raised before your lordship is that the procedure has not been followed. Either one of the two will be correct, my lord. And your lordship, this is the order which page 22, my lord. And then these orders are there after the format in Form B, which is passed, my lord. Now the grievance which is also being raised, my lord, that there is an order of 24th which was supplied subsequently, my lord.
Yes, that's important.
Yes, my lord. This is, I have to deal all, my lord, I take the argument to be correct for a moment without admitting anything, my lord. The service of the region order is after 28 May. That is what they are trying to say, my lord. The service of the order is, and not. I take this argument to be correct for sake of argument also, my lord. The effect is that they have got the regions of 24th, my lord. And they have also got the eviction order. An eviction order granted how much time to, my lord? Kindly see one eviction order which they have, it was granted to them 30 days, my lord. Kindly see 30 days. The 30 days, I'll read only one, so full of typographical error. I am also, my lord, but be as it may, your lordship will see that it says that by order, comply with the order by 11th August, my lord. Now, they have admittedly not, so they have got the speaking order and also order in terms of act, my lord. Kindly see section 4. So to say that it's like splitting the hair. They have the regional order 24, which they can appeal before the appellate authority, my lord. That they are not precluded from, and I am also not praying that they should not be given the opportunity to go to the statutory authority in accordance with law. I can't say also, I can't argue also, my lord, that they have right to go and they should go. My lord, in this context, kindly see section, the scheme of the act, my lord, scheme of the act.
Yes.
And then your lordship, definition clause 2B is corporate authority, my lord.
Yes.
There is no dispute that MTC is a corporate authority, my lord. 2D defines premises, my lord. And 2F is public premise. All these three things have not been disputed. MTC is a corporate authority. The tenanted premises in which they are residing is also public premises, my lord. And then the procedure is laid down in section 3, how the process is to be followed by the deputy commissioner when a petition or application is made by public authority before deputy commissioner under the act, my lord. Because now section 3, your lordship may kindly see. If the deputy commissioner is of the opinion that any person are in unauthorized occupation of any public premises and that they should be evicted by the deputy commissioner, shall issue in the manner here provided a notice in writing calling upon all persons concerned to show cause why an order of eviction should not be made. So, your lordship, I have read out the show cause. My friend has also not denied that show cause has been. Notice specify the ground on which the order of eviction is proposed to be made. So, two grounds have been stated in the notice. One, that the lease or the tenancy has, I will say tenancy, one-to-one tenancy has come to an end, my lord, under 2A, and this is the only and bona fide requirement. The ground was given up by the MTC, my lord, in terms of that. Now, the deputy commissioner 3, my lord, section 3, subsection 3, deputy commissioner shall cause the notice to be served by having a fixed outer door or some other conspicuous part of public premises in such manner as may be prescribed upon notices. So then there is no dispute that so far as this aspect is concerned, procedural aspect is concerned, my lord, there is no dispute that notice has been served and reply has also been filed. Now kindly see 4. if after considering the cause. So what is required before the Deputy Commissioner? If after considering the cause, which I have placed before your Lordship, if any, shown by person in pursuance of notice under section 3, and evidence he may produce. It is not that he must produce, it is a mandatory requirement. Because what your Lordship knows that decree can be passed on the admission. Order 12, Rule 6 decree can be passed on admission. So this, in every, what my friend is saying, that evidence is must in all cases when you have admitted the fact that you are a tenant, you have admitted that tenancy has come to an end. What evidence you would like to place? And make in support of the same, and I assume, my lord, that I am wrong here. Can't they question this aspect in the before the appellate body, my lord?
Yes.
That's in writ jurisdiction. And after giving a reasonable opportunity of being heard, we have your lordship has seen the order sheet. The other order sheets will be shown by my friend Mr. Sen. The Deputy Commissioner is satisfied that public in unauthorized occupation may make an order of eviction for reasons to be recorded therein, directing the public shall be vacated by such date, not being earlier than 15 days from the date of service, as may be in occupation thereof or any part thereof, cause a copy of the order to be affixed on the outer door or some other conspicuous part of the public premises. And if persons refuses or fails to comply with the order of eviction, the Deputy Commissioner or any other officer duly authorized by Deputy Commissioner in this behalf may evict the person and may take possession of this matter, my lord. So the submission which I am making, my lord, is that there is an order passed by the Deputy Commissioner on 24. There is an order giving them time for 15 days on 28, my lord, which is pursuant to 24. Now they are in possession of the premises for more than almost 1 month, my lord. Your lordship, if your lordship is of the opinion that this period is short, your lordship may extend the time. If there is some defect in notice, that defect can be cured, my lord. But whether the substantive right on the technical plea can be taken away, my lord, we have no, whatever is will be falling from this honorable court, we will follow, my lord. But the design or agenda of the tenants whose agreement is month to month have come to an end is to delay the or prolong the proceedings, my lord. And because we are suffering on account of that, we have got the funds, we have to develop under the smart city projects, and therefore some of them have probably, I am informed that they have settled also. And out of 48, your lord,
settled.
Some proposals earlier, on earlier round, they have vacated the premises, my lord.
Okay, anything else? Yes.
So, and then section 8, my lord, lastly section 8.
Appeals.
Appeal. An appeal shall lie from every order of Deputy Commissioner in respect of any public premises under section or section 6 of the Board of Review. So, my lord, appeal will lie from 4 and 6. The order which was appealed earlier and the plea which was taken before the Board of Revenue was that, look, and before Deputy Commissioner, I have preferred the appeal, granting time to the tenants to file the evidence, therefore do not proceed. All these factors taken together, my lord, in my humble and respectful submission, so that it is nothing but it is a case of dilatory tactics, and therefore to that extent they have succeeded in for 2.5 years, my lord. They want to succeed for some more time. That is what
they want to be in a stronger bargaining position. That's all.
I beg your pardon, my lord.
They want to be in a stronger bargaining position. That's the only thing. Yes. That's all part of the game. You can't grudge them that also.
They have followed 2 years. They are there, my lord, and this building is in dilapidated conditions. We are following the process of law, my lord, and your lordship, under Public Premises Eviction Act, we have whatever we could do, we have done it, my lord. It's not that we are against them, but
we will pass orders then.
I'm sorry to interject. While my learned friend is submitting, I am a little confused, my lords. Who is arguing before your lordships? Is the Deputy Commissioner arguing, or is it the MPC arguing through the Advocate General of the state?
Yes.
Smart City project, dilatory tactics. Somebody who's defending the order of a quasi-judicial authority.
My answer is resisting the court, my lord.
We'll overlook that because it's all, if we've come before a court, you come for a court of equity, so we have balanced equities. We, of course, equity can't overcome the law, but I mean, if this, that's the only thing.
If I may, had it fallen from anybody else, different issue.
Advocate General.
Constitutional authority, means Advocate General representing an independent body who's supposed to decide my fate on the basis of law, is actually espousing the case of a corporation.
Yes. 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 Anything else?
So, Lordship, I just address Lordship on just a few points.
Yes.
I'll be brief, Lordship. If my learned seniors completely
taken enough time, yes.
Lordship. So there are just two grounds on which both writ petitions have summarized their arguments. One is that there has been a violation of the principles of natural justice, and number two, there's been procedural defects.
Yes.
Now, as far as procedural defects are concerned, Form B is not in compliance with the statutory form and so forth. Let us assume for a moment that is correct.
Yes.
But does that go to the aspect of jurisdiction? Is that a violation of principles of natural justice? In my humble submission, it is not. It is not enough to invoke the remedy under Article 226. This is very well an appealable order. Now, very quickly, my learned senior had argued that the Evidence Act is applicable, and by not affording them an opportunity of cross-examination, there has been a violation. Kindly see page 298 of this judgment, the last page. Paragraph 57.
Yes.
If Lordship may just read this. We, however, must not shut our eyes to the objects for which the Act was enacted. It provided for a speedy remedy. The estate officer is expected to arrive at a decision as expeditiously as possible. The provisions of the Code of Civil Procedure and Evidence Act being not applicable, what is necessary to be complied with is the principles of natural justice. Now, the state has taken the liberty to prepare a small compilation. I've been given a copy.
Just the show cause.
Lordship, this is what was not enclosed as part of the writ petition. Now, from para 1 onwards is the show cause which was filed by Sanjay Kumar Shom, which is item number 3. Now, kindly see page 6. I'll just refer to a few pleas. Page 6, para 17.
Page 6, 1 second. Yes.
This reads that in view of the aforementioned circumstances, it is most humbly prayed that the undersigned noticee may be allowed to adduce evidence for proving the averments stated above, for which a convenient date may be fixed, and only after affording the undersigned noticee an opportunity of personal hearing. Kindly note that, fellows. They're asking for personal hearing. Necessary orders may be passed. Thereafter, kindly turn to page 8. This is the order dated 22/11/22, passed by the DC.
That's not on the record in the...
This is not on record. They did not file it along with their writ petition.
22 and 22.
22/11/22.
Yes.
Can you see the last paragraph?
Yes.
The counsels of the respondents submitted that the process of eviction is not maintainable since due process of law was not followed, and they prayed for another week's time before they can file their written submission before the DC is khasiyas. So they waived their opportunity to file lead evidence. I'll just come to that. Kindly see thereafter at page 9. This is the order dated 10/1/23. This is enclosed with the writ petition. If Lordships have this?
Yes.
The second paragraph. Seen applications filed by the occupants' tenants praying that the MTC landlord adduce evidence first. So they adopted a different course of action now. At this point.
Oh, yeah, okay, yes.
Page 9.
Yes.
The second paragraph.
Yes.
So seen applications filed by the occupants' tenants praying that the landlord MTC adduce evidence first.
Yes.
The counsel for the MTC has agreed to lead evidence without any further delay in the proceedings. That was one of the reasons why we agreed to lead evidence. Now kindly see thereafter. At page 11 is the order dated 8/6/23. I'll refer to the third paragraph. This has been enclosed along with the writ petition as well.
Yes.
As per the order dated 10/1/23, issues have been framed and it was directed that the MTC shall file their evidence by affidavit. The same has not been filed, and the counsel for MTC has explained today that MTC does not want to file any evidence to establish bona fide requirement of the premises, as MTC has requested eviction on the ground of expiry of tenancy agreement.
Yes.
The date was fixed on the 14th of June 23, with Lordships will find in the last paragraph.
Yes.
Okay, this is important, my lords. An adjournment application was filed on the 14th of June. This is at page 12. Now, all the 26 writ petitioners in item number 3 filed similar identical applications. Now, kindly see what this says.
Yes.
The humble applicant tenant has received a letter dated 9/5/23 along with the order dated 8/6/23 passed by this honorable court, that the humble applicant tenant prays for 14 days time to comply with the directions as per the order dated 8/6/23. Absolutely very important. They write to the DC seeking 14 days time. Kindly see further. In the premises aforesaid, it is most humbly prayed that your honor may be pleased to adjourn the matter today and grant 14 days time to comply with the directions as per the order dated 8/6/23. And this is signed by the parties concerned and it is verified by the parties concerned. Your lordships will find the verification at page 13.
Yes.
Thereafter, they preferred an appeal against the order dated 8/6/23. So they agree to filing their affidavits. They file an application asking for 14
so they
days
were
time.
allowed by 26/6.
Lordship.
They were allowed.
And thereafter they turned around and they go and file an appeal.
Yes. Yes.
Now, Lordship, if for a moment Lordships are inclined to allow the writ petition on whatever grounds they have raised, may I pray that Lordship will give a specific direction, a time-bound direction to the DC to complete the PP proceedings. Otherwise, what is going to happen is, if there is no time-bound direction, they will continue it for the next 6 months. I would pray for a direction for 30 days, my lords. That is only if Lordships are inclined to entertain the writ petition.
Okay, we'll pass orders.
Lordship.
I have to respond to a couple of issues. I'll take just 3 minutes of your lordship's time. But before that, Millets, it is my duty to inform your lordships that in the course of the hearing, Millets, we have been informed that form proposal B, which was given by us yesterday, in principle has been accepted by the MPC. I think my learned friend has also.
So I've already taken instructions from the MD. It's in principle, but again, these proceedings should not be stalled. Those are the clear instructions
that
I have.
I did not make this submission.
So we'll do one thing. I'll hold back the passing of orders. I'll pass orders on Monday. You just inform the court.
Lordship.
No more submissions. Yes.
Lordship.
Well, it's just 2 things I'll have to clarify before your lordships. I'll take just 2 minutes of your lordships.
You've taken a lion's share, Mr. Paul.
But the brunt of the fire from the Advocate General and my learned friend for the MPC has been on the 29 petitioners.
Yes. Yes.
I don't
Yes.
know, but
I had only one small submission.
Yes.
But my friend, the Advocate General, was referring to Annexure 1 of my petition, and then tenancy is admitted there. But I have also filed the show cause which we have filed before the Deputy Commissioner. That is also on record before your Lordship, and there we have categorically denied that. We have said that, if I can take your Lordship, page 21, Millard.
There's one more.
Malcolm.
And before I just forget, I just add one more thing. The State Act does not contemplate a personal hearing. It only speaks about a reasonable opportunity of hearing. The Central Act contemplates a personal hearing. Let's have a copy of the Central Act. So the standard of proof, insofar as the State Act is concerned, it's much lesser compared to the Central Act.
Even then, we only the basic premise of like exercise part 226 and make to show whether the orders are patently and blatantly illegal, that that all procedure has been given goodbye. Anyway, yes.
But anyway, at para 21 in page 4 of the show cause, para 4 of the show cause,
page 11.
Page 21, Milan.
Of your writ petition. Yes.
21. This is the show cause which we had filed, Milan.
Yes.
Para 4, Milan, that the relationship between the MTSC and myself is governed by the urban areas and control, subject to the fact that in addition to my possessory rights on the said tenancy premises, I have also acquired ownership rights thereon.
Having that they have established by suit.
So, whatever, yes, that is true, but where is the finding on this?
There's no.
Where is the finding? Let me complete, Milan.
Yes.
My friend is giving the finding now. My friend, the Advocate General, is giving the finding. I'm surprised, Milan. Alright, I'll leave it to your lordship.
Yes.
I'll just take 2 minutes of your
Yes.
It's 2 things have been submitted. Very quickly deal with it. A lot of emphasis was said, Malads, that I had filed an application seeking that I will comply. Then I go and file an appeal. I have never urged for 1 second, Malads, that the pendency of the appeal should have been one of the reasons why the proceedings should have been kept in abeyance. Yes. That is on the merits of the matter. I categorically pointed out before your lordships, I am not going to go on the merits of the matter.
YouTube of the hearing, Milord, my friend has made this submission here also. I can now it is recorded, everything. Submission is there. That I can say.
I could not follow my friend, Milord.
No, what the recording of the early proceedings? Yes.
No, before this honorable court only, submission was that in appeal it was made that since the matter is pending before appellate authority, please do not proceed with the matter.
Oh, that we file an application, that is there. That application has been filed. You've dealt with it in the order. I'm saying
one thing, only the statement of Advocate General committing the affidavit, not the other counsels. Remember that. So
which is why, my lords, I raised that objection. It's coming from the Advocate General, smart city.
Yes, what do you want to say?
Well, what I'm saying is, that is not relevant for the purposes of adjudication of this particular matter. Assuming, my lords, I said that I will comply. I did not comply. I did not file my evidence. They granted me time, my lords. Definitely this order of 26(6) is again a... My lords, I will just stop short of saying... Because people were running around to catch hold of any copy of this order, my lords. It's never been filed by anybody. MTC produces it there. There's a writ petition. In my writ petition, specific government, no orders passed. Now some order has surfaced. I will not say anything on it. But assuming, my lords, I did not file, then evidence would have to be closed. Matter would have to be heard. Point is, my lords, I'm guided by a small judgment of the Honorable Karnataka High Court, my lords, that would have some, my lords, persuasive value before your lordships, my lords. This is AIR 1980 Karnataka, page 186, my lords. They've put it very nicely, if I may just place it before your lordships, paragraph 13. AIR 1980 Karnataka, page 186.
Okay.
This is, my lords, Blaze and Central Private Limited versus the Union of India, my lords. Paragraph 13, if your lordships kindly have.
Yes.
From which part?
It's a long paragraph.
Well, from the mid of the paragraph, my lords, 1, 2, 3. I'll just read it very quickly, my lords. So, this takes me to the second contention relating to the denial of natural justice. Learned counsel for the petitioner has urged that the estate officer did not record the statements of the witnesses produced by the bank in the presence of the petitioner, nor yet furnish a copy of the statement that the witness, in spite of specific... This is on facts, my lords. District judge has summarily rejected the latter. The reasoning would lead to the trap of legalism of the 17th century. The act need not provide, my lords, I'll skip that. My lords, the estate officer, if your lordships have that.
Yes, must hold an inquiry.
The estate officer must hold an inquiry as required under section 4 of the act read with the public premises eviction of unauthorized occupants rules 1971. Rule 5 of the rules provides that an estate officer shall record the summary of evidence tendered before him, and the summary of evidence and any relevant documents filed before him shall form part of the record of the proceedings. Exercise of power under the Act is undoubtedly quasi-judicial. The petitioner has a right to be heard before the estate officer, and if the right to be heard is of real right, which is worth anything, it must carry with it a right to know the evidence of the opposite side. The petitioner must therefore be told what evidence has been given or what statements have been made by the opposite party. In other words, to put it shortly, the petitioner must be given a fair opportunity to correct or contradict the statements of recorded or the evidence collected in his presence or absence. This one principle uniformly appears in the cases commencing from so-and-so. Well, and then it just goes on. Well, it's on the right-hand side of that same paragraph, your lordships will see, a tribunal or a person on whom a judicial or quasi-judicial function are entrusted is thus presumed to have an obligation to act with fairness. That is not only the obligation to observe the principles of natural justice, but on the contrary, to observe a higher standard of behavior than required by natural justice.
Yes.
This is the part, my lords, that I am emphasizing on. A responsibility has been cast upon you to, my lords, adjudicate. You have to not only comply with the principles of natural justice, but the standard should be such, my lords, that your conduct cannot be questioned. Well, it's that one judgment which was placed by my learned friend Mr. Sen. You played this New Indian Insurance, right? This entire issue of, my lords, who leads evidence first or not actually falls from this particular judgment itself.
From Karnataka judgment?
No, not Karnataka, my lords. This is what my friend had placed before your lordships, 2008 3 SSC, page 279.
Yes.
Lord, I would have dealt with Karnataka judgment had my friend argued in his ambush tactics which he follows. In rejoinder, he cites a new judgment which I didn't. I will place a note on that point, my lord, and Karnataka judgment, how it is distinguishable in facts and law, both.
That a higher standard of proof is required. I'm sure my learned friend will be ably, my lords, distinguishing.
Yes, 57.
Well, I have no, your lordships may kindly have paragraph 31, my lords.
Yes, with an application.
Melons. Application of the Act and rules. Para 31 down below, melons, they say under what circumstances, then 31. When an application for eviction is based on such grounds which require production of positive evidence on the part of the landlord, in our opinion, it would be for it to adduce evidence first, more so in the composite application where the evidence is also required to be laid on the quantum of damages.
But
they've waived that right.
For a moment, this judgment does not say what my learned senior is trying to urge before this court. This says there are two classes of tenancies, Nusley's case. The first class of tenancies is where the occupation or the time period expires by flux of time. They don't have to lead any evidence. It's quite the contrary to what he's saying. For this judgment, kindly go through page 25 onwards, para 25 onwards.
That's what I pointed out.
Thank you.
Well, yes, and of course, this last judgment I'd already pointed out. Your lordship's judgment in Sumarlin Wankhar's case versus Secretary KHDC, where lordships have again followed Whirlpool and
regarding
alternative remedy. Para 18. Okay, we've already submitted a copy on the last occasion, but we'll give another.
Heard in the council parties, as there is a possibility of further developments in the matter. Judgment will not be rendered today.
By Monday?
By Monday next week, yes.
Monday.
We have to list it. Because we can't just you list it on.
Well, it's what I am told. My instructions are they have said that they'll do it within the next 1 or 2 days. So we can probably come back to your lordship. Tuesday. Let it be on Tuesday, my lords. So there'll be orders. 2 working days. If it's settled, my lords, will not burden your lordships.
Interesting position, but yes. Next matter.
Item number 4.
Yes. So you got the money?
Lordship, we have been communicated a letter where it appears that now the district judge has to submit all the relevant bills.
No. Money has been sanctioned 27 lakhs. You haven't got that?
Yes, it has been sanctioned. The further instruction is we have received a letter on 15th of August, my lord.
The sanction letters when?
Of 9th of August.
Yes.
On 15th we have received another letter
which was actually issued from the, it's a communication between the judge, district judge and the department. In connection with that, they will, my lord, forward all the papers and thereafter the bill will be released.
Yeah, the money already sanctioned the district judge. Why are you banking on what the district judge is saying?
So in that case, my lord, let a time frame be fixed and we'll...
As far as we are concerned, what time frame would be framed? What sort of a writ would lordships issue? As far as we are concerned, we have already sanctioned the entire amount.
So it's over.
It's just a matter of time.
No, release, my lord, that let it be released within some
as
reasonable
expeditiously
time.
as possible.
Yes. By order dated 28/8/2023, the learned GA had produced a letter dated 9/8/2023, which indicated sanction for an amount not exceeding rupees 27,91,600 for payment of house rent had been communicated. The counsel for the petitioner was allowed to obtain instructions. But today, Mr. Bidep submits that. What do you submit?
Lordship, I've seen that.
There are other attendant factors which how are you privy to the internal communication between
No,
the
a copy
district
was
judge
marked,
and
a copy was marked to us.
Let's see that.
I don't have the printout.
Then, what kind of submissions are you making?
No, what I'm only trying to say is, Lord, there's a sanction. Money has been released.
Then?
So let them pay it within a very reasonable time because it's 3 years old bills.
I record you have no instructions today. Today, Mr. Bidep has no further instructions, no sufficient materials to dispute this fact. So, in that view, the matter is closed. It's expected that the amount of sanction will be released as expeditiously as possible, preferably in a month within a period of 1 month from today. Yes.
Much obliged. Only my lord, S-Dep.
S-Dep, sorry.
Obliged.
Item number 5.
You'd have more peculiar names, than
Lordship, yes.
Yes.
Item 5 also, my lord.
It was a little close. What has Chachi's been filed?
No, well, may just point out, apparently what was submitted on the 20th may not be the correct position. We've just received instruction that charge sheet has not been filed. This was miscommunicated to us.
Then?
And there was some confusion with regard to a different case. Kindly give me time till about tomorrow or Monday. I'll take proper instructions in this matter.
Yes, though it was submitted before this court on 28/8/2023, the charge sheet had been filed consequent to the filing FIR. However, Mr. SN today appears you are allowed to obtain further instructions. Just a matter of the 1 week.
Highly obliged.
Much obliged.
Main list, item number 1.
Yeah, my lord, we have filed the affidavit today itself.
I have just received this morning, Your Lordship. I pray that matter may be listed for hearing.
No rejoinder.
No, Your Lordship.
Yes, after it's been party submitted, please complete this matter for hearing. So on, so on.
Obliged, Your Lordship.
2.
Obliged, Lordship.
Your Lordship, the respondent number 5 are yet to file the affidavit.
Lordship, I'm paying for another 2 weeks' time to file my affidavit.
Status order.
How many times you prayed?
This is the second time.
MSE 1 year for R5, please for further 2 weeks' time to have this thereafter.
3.
Very unfortunate, my lord, the client has not come to sign the affidavit. I've sought several times. In fact, my lord, I may contemplate withdrawing myself from this matter. The last opportunity may be granted. Let's. If next time she doesn't come, we'll withdraw ourselves.
What's the matter about? Mr. Kharmi, yes, what's the matter about?
My lord, it's about violation of the provisions of the Meghalaya Transfer of Land and Regulation Act.
Have you filed affidavit? No.
No, Lordship.
Why?
Lordship,
None
this
appeared last
matter,
time also.
I have not received any reply, Lordship. Lordship, this from the respondent 1 and 2, Lordship.
Then what are you going to do?
In this matter, Lordship, the only grievance against the respondent is the non-disposal of the representation filed by the petitioner, Lordship. Only that much only.
So you won't file affidavit?
It's not required to file the affidavit.
Mr. Philemon Nongri, learned counsel for respondents 1 and 2, submits that due to loss of contact with the respondent, he was unable to file the affidavit stuff. Next, Mr. H. Karmi submits that the point in issue in the instant petition is limited to seeking directions for disposal of certain representation dated
dated 21/7/2022,
which has not been disputed by the petitioner. Oh, this is the, not 21/7/22. Where's the representation? I hope not. It'll not open, another cause of action. That's the only thing. Sometimes repetitions are very innocuous, but
My lord, prayer was also made to evict the respondent number 3
from by writ petition. Yes, very good.
that it cannot be done, Lordship. Direction to evict them without following.
So
the
within how long? Within
process
one day
of law.
for eviction. Yeah. Where's the 21/7? Is there title suit pending also?
Title suit also is there.
Dismissal default.
This is the fault. That's why you don't want something to open up to give another cause of action. Stop. Where's the representation?
21/7/2022. 21/7.
Is that the next?
21/7. 3 and 4. 3 and 4.
Where is it?
3. The date is not
annexure
mentioned
3.
here.
It's annexure 3, my lord, page number 21.
Page?
Page number 21.
21 or 21. Yeah.
What is that? 21/7? This is May 22.
21st July is the receipt.
The receipt of the in the office. The date of the petition is May 22. Annexure in the paragraph it is mentioned in paragraph 9, and it's given as annexure 3 and 4. I think it's annexure 4, Lordship. Page
No,
25.
what the court wants to know is whether you file a civil suit and the same you are unsuccessful, you're trying your luck again by this application. That's the only thing.
That's the position.
You see, if you're trying to open another cause of action and the matter is already is business default, you could not restore it. That's to your detriment. But if you're trying to open another area, where you can again agitate your rights by bypassing the civil suit, ever you file whatever is there in the civil suit. Have you annexed a plaint here? No.
No. It's annexure 4, page 25, Lord.
The plain.
The representation, Lord.
No, annexure 4 is just a reminder. Where's the reference to the title suit? Where we made it in writ petition?
It's not mentioned.
Is that mentioned?
It's a quota of 2008.
File a suit, paragraph 5.
Paragraph 5.
Paragraph 5.
What happened to the suit?
This wasn't.
You're the leading counsel here. Elected by whom?
Senior Advocate A.S. Siddiqui. Mr. A.S. Siddiqui.
What form then? Next one. Be that as it may, as the facts don't seem to be clear before this court, this is matter after 1 week. Tell your senior to appear, then we'll know. Otherwise, you can't pass directions allowing you to open up on a new front. Yes.
I don't know.
Item number 4.
Your Lordship, we are for the petitioner. We have filed adjournment for the day, Your Lordship. Our rejoinder is ready. We have sent the same to the petitioner for getting his initials. Your Lordship, kindly allow us 3 weeks.
Filed for seeking for the time for filing of show cause reply to the application of 7/11. For how much time?
3 weeks time, Your Lordship.
Yes. For seeking 3 weeks time. Prayers allowed, applications allowed, list up to 3 weeks. Yes.
Highly obliged, Your Lordship.
5.
Please, Your Lordship. Your Lordship, I'm praying for further 2 weeks.
Why?
time, Your Lordship.
You're not interested in pursuing the matter
Your
anymore?
Lordship, actually here the conducting counsel was supposed to send me the reply, Your Lordship, but he is not keeping well.
Same order. No? How much time? 3 weeks?
3 weeks would
3 weeks. Same order as earlier one.
much obliged.
Application filed for civil level application.
Much obliged.
6.
You've given them the money? Yes. Have they received the money?
Lordship, no. Order was passed 2 weeks back, giving them 1 week's time to make
Why?
a payment.
Lordship, as per instructions I've received, instructions that new facts have come up, whereby the FIR where it's found that there was no FIR which was filed with regards to this issue, and there was no complaint which was also filed with regards to the electrocution case. So the electrocution case, when this matter was taken up, Lordship,
Is
the
there an officer
department,
present on Monday? Who's the concerned officer? Who's the concerned officer who's dealing with this?
Lordship will be the MD, Lordship, MD of.
Tell me present.
Lordship will be preparing a review of the order, Lordship, because Lordship, if I can take your Lordships to the petition, there's no FIR or any complaint which was filed in the petition also, Lordship, except for the medical certificates which were recovered from Nazareth Hospital.
Is there any doubt as his result?
Lordship,
of accident due to
exactly,
electrocution?
Lordship.
Yes or no? There's a doubt.
There's a doubt regarding electrocution which is attributed to by MECL. Lordship, because if, as per my instructions, if there was an electrocution by MECL, there will be an FIR which was filed, and police will be known of that. And upon that, the hospital which was referred to will be filing that FIR, the complaint, and will be referring that complaint to the police. And for the purposes of compensation,
This ER certificate by the hospital says electrical burns.
Medical burns, Lordship, but then we are not. It was not satisfied whether it was by MECL or it was self-inflicted, Lordship.
Self-inflicted, what do you mean?
Lordship, my apologies. Not self-inflicted, Lordship, if for somewhere else.
Somewhere else?
Lordship.
Person loses both his arms and legs. He self-inflicted himself.
Lordship, my mistakes were wrong. Not self-inflicted, Lordship. Somewhere else.
Yes, Mr. General. What will we do? They're disputing the very factum of the accident also.
Lordship, two things, my lord. Firstly, with respect to my friend, I am not sure where these submissions are coming from, inasmuch as what does my friend hope to achieve through these submissions today? Because there is an order, there are in fact 2 orders of this honorable court. Orders have to be complied with, my lord. Orders have to be complied with.
You call officer.
And just to inform this honorable court what has been happening on the ground.
Yes.
Day before yesterday, my lord, petitioner gets a call saying that the MECL persons want to conduct a spot inspection of the place where the accident took place. Now, petitioner told them that there is an order of the court for you to make a payment, comply with the order, then we talk of spot inspection, etc. After 5 years, I'm not sure what they want to inspect at the spot. Number one. That was day before yesterday. Yesterday, petitioner my lord gets a call from MECL saying that please come to our office. The check is ready. Come and collect the check. Today morning, sometime back, he goes to the office. He's told that no, we will not give you the check. We'll wait for the order of the court. If required, we'll transfer it online. This is pure harassment. This is pure avoidance of
By order
punishment.
dated 17/8/2023, the Respondent Corporation was directed to release the ex gratia amount to the writ petitioner within a period of 1 week therefrom. Stop today, Mr. H. Karwanlang has sought additional time and raised issues and raised
Lordship,
what are your objections as to the
with regards to the
admissibility of the petition? Next one. The order of the court is 17/8/2023 is categorical in its directions. The concerned officers to appear personally before this court on Monday at 10:30 a.m.
Lordship, if I may, Lordship, if matter can be taken up on Friday, Lordship, if filing a review petition today, if
Monday 10:30, the review against this order will be rejected. I can tell you right now, sitting here. Yes.
Lordship.
Obliged.
Yes. 7
Item number 8.
It's only been disposed, Mr. Jha.
My lord, it's wrongly listed. That's what the submission.
Yes.
Order dated 24th August. It's quite clear.
Item number 9.
What do you put plans? Okay. Yes.
Lordship, here the private respondent has to file their affidavit.
Lordship, I'm for respondent number 4, Lordship. I'm playing for 3 weeks' time to file my affidavit.
You filed number 4?
I'm for respondent. No, you. Lordship.
You 1 to 3 you filed?
Yes, Lordship.
Yes. For 4 response or further 2 weeks time to file affidavit this thereafter and so on.
You pledge Lordship.
10.
Yes. 1, 3 and 5 and 4.
May I please, Lordship? Lordship, I'm praying for an additional time, Lordship, to find my.
No objection.
No objection.
3 weeks further time granted response to file affidavit list thereafter and so on. So.
You obliged.
11.
Respondent number 5, my lord, is yet to file the affidavit.
Yes.
Your Lordship, I'm appearing on behalf of Mr. Jishila. Lordship, I pray for 2 days' time.
2 days' time? 2 days be Saturdays. You're filing
Monday.
Your name?
Jakso.
Jakso on behalf of number 5 submits that the affidavit will be filed within a period of 1 week. This thereafter and so on. Affidavit on behalf of respondent number 1 to 4. It's already on record. This. Right.
12.
Your Lordship, I'm praying for some time, Your Lordship, to file the affidavit. We had received inadequate instructions, Your Lordship.
Yes. MS also please phones allowed for the 3 weeks time to file affidavit.
Obliged, Your Lordship.
13.
Yes. MSR Kohli. Where's the petitioner? Yes, who's the petitioner? None appears with the petitioner. Let's stop. Officer indicates that service respondent 4 and 5 is not complete just after 3 weeks. First service report.
14.
May I please, Your Lordship? Well, I'll be requiring some time to file a small affidavit in this matter. I'll pray for 3 weeks' time, my lord. Positively, I will file it.
What's a matter of Nokma?
No, my lord. This is a matter of bill, my lord. Payment of bill.
Relax only, pay him.
Just we have to cross-check, my lord, whether the work was done or not. And whether he falls in that category.
Further 2 weeks time to file
I'm praying for 3 weeks, my lord. Positively.
3 weeks.
Obliged, Your Lordship.
15.
May it please your lordship.
May it please your lordship, we've already filed the affidavit. However, I'm praying if this matter may be called up after some time, your lordship.
You got affidavit? You received
Lordship, I
it?
received.
What does it say?
Lordship, they say that he does not know, the ADG says he was not aware of the posting order of the BSF, but from the annexures, Lordship, I can show that he was the one who has approved it, Lordship. His own annexures, Lordship, says otherwise. And Lordship, 31-1 order, he was aware of that, and even after that, receiving the NOC from the AR, he did not issue my posting order.
Where is that?
Lordship,
In the affidavit?
page 15, just a minute, Lordship. NOC, Annexure 1, Lordship, page 6, 15/3/2023.
Annexure?
1,
Or the affidavit page?
Lordship, page 6.
What do you say?
It says that the draft revised policy regarding posting and transfer of specialists and ZDMO so-and-so still is under consideration. However, in view of the present strength of ophthalmologists in the force has no objection for posting of ARMC Commandant Dipankar Chakrabarti to Composite Hospital Border Security Force.
Okay, then what happened after that?
After that, Lordship, the ADG was, according to the order of 5/4, Lordship, 5/4/2019, my posting order, the ADG was supposed to give my posting at BSF, but he did not give my posting even after receiving this and sat over it. Thereafter, Lordship, BSF...
This is dated when?
This is dated
15/3.
15/3.
Okay, yes.
So after that, in June, Lordship, he sat over the matter. In June, some nomination was given by the BSF to his office. He only approved it, Lordship. And my order still stands, dated 5/4/2019, Lordship, my posting order. Without cancelling that, he approved another order. And Lordship, he says that he has not received the order dated 8/8/2023 until 17th. On 17th, he had intimated the BSF and everybody, but still they allowed the joining on 18th. But Lordship, we had sent the email on 8/8 itself. A copy of this mail, Lordship, with the order.
This, what's the name of that ADG?
ADG Tapan Bishwas, Lordship.
Where is that? Where's he signed? Where is this order?
Affidavit, Lordship, page 5. He did not give his full signature, only initials. And Lordship, page 18, Lordship, if Lordship goes to page 18, Lordship will see that he himself has written that the BSF had sent the proposal to his office. Wide order dated 19/6/2020.
Where, which page?
Page 16, Lordship, Annexure 4.
Yes.
His own order, Lordship, in reply to Med Signal so-and-so, vacancy of eye specialist exists in CH BSF Padgaon. However, BSF has submitted a proposal to ADG Medical Office for concurrence regarding posting of specialist medical officer, in which posting of one eye specialist of BSF to CH BSF Padgaon has been proposed.
Till then, no approval was given, Lordship. The proposal of BSF was forwarded to MHA via office letter number so-and-so. In reply, MHA has directed that the new transfer policy dated so-and-so is under consideration in MHA in consultation with all stakeholders. Till then, status quo may be maintained with regard to the process of annual posting transfer of specialists with PG qualification to all forces. Even after this, he allowed the posting of that BSF candidate, Lordship, when the matter was sub judice. It is in total violation, Lordship, of the court's order. Even MHA said that status quo be maintained. And next page he says, hence,
this is his letter only.
His own letter.
Yes.
And then last he says, considering the decision of BSF to post one eye specialist, there will be no vacancy left out to post Dr. Dipankar Chakraborty. Only on the proposal he has said that.
It's 10/7/2023.
Lordship.
Yeah.
This was after we had sent a legal notice and for not complying with the order. And Lordship, in the next page, some Inspector MHA has written at page 18,
Yeah.
E. In bold letters, he has written, ADG made is of the opinion that it will not be practically feasible to post Dr. Chakraborty of ARs to CHBSF Padgaon. So it shows that he is the one.
What is this, Dr. Mazika? A blatant violation of orders.
Well, the violation has happened, my lord. And the violation, how it happened, my lord, because of the circumstances, because BSF was not a party, my lord, in the writ petition.
Even then, see, look at this page 16. This annexure 4.
Annexure 4.
His own letter of this ADG. Para 4, see.
BSF has submitted a proposal to ADG Medical. He himself has stated that BSF has submitted a proposal to him. That too on 19/6. And our order was dated 31/1/2023. And then MHA has, he himself stated that MHA has stated that status
See,
quo
by himself,
maintained.
then status quo may regard process annual posting of specialists. Then even at page 18 highlighted.
Regarding posting. In respect
See, even
of
this page 18.
Yeah. Someone else has written that ADG is of the opinion. Because BSF has stated that there is one vacancy.
Or in fact, I told him, because what the ADG Medicals informed me, my lord, that the BSF's transfer has happened without his knowledge, my lord.
He himself has stated that.
No, as far as the status quo is concerned.
Yeah,
After the status quo order was passed on 8th of October,
BSF has submitted a proposal to ADG Medical Office for concurrence regarding posting of one eye specialist of BSF to CHP. So he knows about the posting. And there was an order to consider Dipankar Chakraborty by the division bench also. And my posting order dated 5/4/2019 still stands, this one. Here there was an advice given to the ADG is requested.
Where is that?
to
You don't
issue
submit to the, you submit to the court.
Lordship.
Not to your
Lordship.
other consuls.
Because Lordship, in the 5th of April order 2019 also, it was
Where is
stated,
that order?
in our writ petition, Lordship, annexure 3, page 35, Lordship, a copy here.
Then we have to institute contempt proceedings. Dr. Mazika.
my lord, what I pray, my lord, if some one line is directed, we will revert the things, my lord.
We said contempt will ensue.
But the difficulty, what happened, my lord, the ADG Medical, because there is no clarity which policy is governing now, my lord.
By his own statements.
And what has happened, my lord, the status quo order was passed on 8th of October, my lord, that I communicated to ADG Medical.
8th October last year.
No, my lord.
8th August, Lordship.
8th August,
This-
sorry. 8th August status quo order was passed by Lordship. I communicated to ADG Medical, my lord, and to the Assam Rifles because BSF was not a party here. In the meantime, what has happened, because interforce transfer, this was a transfer from BSF to BSF, my lord. ADG medical comes into picture only when it is interforce transfer, my lord. When it is intraforce transfer, my lord, ADG medical was not into picture, his concurrence was not taken, and that's how the order has been, she has been allowed to transfer. BSF was not arrayed as a party. So
we cannot accept that.
This is a wrong submission, Lordship. He himself has stated that the BSF has sent to the ADG office for concurrence.
See your affidavit itself. Just have a look at your affidavit, that page 16. It is as clear as daylight.
This is his own writing at page 16.
See from para 2. See, can they be more damning? BSF approach, how can you say BSF doesn't know? Now I said not then at para 6, hence considering the fact that the office of the opinion that it will not be practically feasible to post dotted punishment to others.
But this is as far as the main writ petition, my lord, the relief in the main writ petition. My lord, the contempt has arisen, my lord, only because of the status quo has somehow been violated.
We'll pass orders, we'll ask for his personal appearance. When it will be convenient for him to come? Where is he posted? In Delhi?
In Delhi.
Yes. We'll pass orders. I'll pass orders.
Charter of Duties also says.
My lord, otherwise, my lord, because what he told me, my lord,
as
he has no problem
the
in
contents of the affidavit as filed by the concerned ADG, what's his name?
Tapan Biswas.
Dr. Tapan Biswas. ADG so reflect that they are violations of the orders of this court. Formal orders for drawn up contempt proceedings will follow. Yes.
Item 16.
Lordship, personal appearance.
No, we'll follow. I'll file it by Monday or maybe today.
Much.
Lordship, with a very limited prayer, we filed these petitions, directing the to accord the approval or not, assign the reasons. The last order, Honorable Court has passed an order stating of the facts and asking the instruction from the number 2. What is the reason for not giving the approval? So today is the date they have to take the instruction and say to the court what instruction they have received from the.
Yes. Mr. Khan, one instruction.
Appearing for respondent
Yes.
number 1. We have received instructions 2 days ago. In fact, what has happened is we have received 2 contradictory resolutions appointing 2 different steering committees and 2 different governing bodies. One is the one that's annexed with the petition, and we have received another resolution as well.
File affidavit then.
Lordship, in this case,
submits that on instructions, as per instructions received, there are 2 governing bodies that have been put up for approval. Directed to file affidavit within 2 weeks.
Very obliged.
And then file when you have a chance to.
Yes.
Hearing supplementary list item number 6.
We were supposed to file the compilation, my lord.
Of judgments? Yes. Compilation of judgment has been filed by the petitioner. Hearing concluded, judgment reserved. Yes.
Main list, hearing 17.
Well, item number 17.
Yes.
When it was heard the last time, my lord, it was taken up with item number 19 today.
Yes.
Mr. Paul suggested that because the file has become very bulky,
yes,
we file a compilation of the relevant papers only.
Yes.
That compilation, my lord, I have prepared and I have presented today, my lord.
Yes. You give them a copy?
I have given a copy.
Given him a copy, my lord. I've given a copy to Mr. Paul also because he will be also arguing a similar matter, my lord.
Yes.
Item 19. My essential focus, my lord, is that the initial order, which is the genesis of all this disputes, my lord. It starts, my lord, with the order in Read-Bill 50 of 2010. My lord, therein the detailed discussion of as to what are the benefits that would flow from the Fifth Pay Commission in Assam Rifles, my lord, that is discussed. There is a table compilation there which says that there will be a class-wise reorganization of different forces. So, people who have done class 3 will be designated as Hawaldaar, class 2 as ASI or warrant, and class 1 will be the SI. My case is, my lord, for class 2 because all these petitioners have done class 2, my lord, and therefore they are to be designated as ASI or warrant officer.
Okay, come to the orders you say have been violated. Which orders have been violated?
The order of this honorable court,
yes,
we are not in contempt of. My lord says that the benefits that are there in Read-Bill 50 is to be also accordingly to us. The Read-Bill 50 order, which says that class-wise promotion and class-wise redesignation and pay is to be granted to individuals. That order is to be implemented in respect of us. And while implementing, Lordship has heard this matter several times. While implementing, what they have done is that they have not given us this benefit of class 2. They have given us this benefit of class 3 only, saying that we make you Hawaldaars. Even though you have done class 2, we are not making you ASIs or warrant officers. And our case is that, in similar cases, in the trade of clerk, in the trade of pharmacists, and in the case of ciphers, my lord, people who have done class 2, they have been made warrant officers, my lord. That is also there are any recruitment rules, warrant officers rules not existing in the recruitment rules anymore. It was reclassified something as, my lord, recommended by the pay commission. Yes. Our case is that in the FLP also that we have now shown in this particular compilation, this specific fee that has to, you are not entitled to the rank of warrant officer, and Read-Bill 50 of 2010 order is not a binding precedent. That was precisely argued, my lord, before the division bench and before the apex court also. Now, after not succeeding in this petitions, my lord, is it open, my lord, for the Assam Rifles again to reinterpret and reopen all these issues and ask us to litigate from the very beginning, my lord? By saying that we give you only this benefit because this is what I understand from the order. Because from their own readings, it is obvious that they understood, my lord, what is the benefit to be given. They registered that particular benefit. They failed in giving benefit. Therefore, contempt arises, my lord. That is the sum of my entire case, and the relevant documents, therefore, I have just given in this particular compilation as to the orders passed in our case, and also the order passed in Read-Bill 50, which is the root case, my lord, in this entire dispute. And also, I have annexed that similar orders, my lord, of granting class 2 warrant officer equivalent rank, because they are referring, my lord, saying that it is only to be extended to 3 grades. That Dr. Mozika has argued several times, Lordship would recollect, that it would be only as per the one that January 98, my lord, circular, it is to be applicable only to 3 grades, But then that has since been extended, my lord. It has gone beyond these three trades of radio mechanic and draftsman. It has gone beyond that trade and it has been now extended to other trades also. And in fact, for all other balance trades, my lord, also this order, this division bench has, my lord, passed an order in which the SLP is now is pending, my lord. The benefits are, my lord, flowing from the original scheme that, my lord, was devised by the Fifth Pay Commission. But then in our case, my lord, we are still stuck in the Havaldar, and that has in fact made us lose pay, my lord, because we have been designated to a particular post to which, my lord, we ought to have been, my lord, initially designated, and not in 1998. Now, people say, for example, I have pointed out also in my other written submissions, my lord, that people who joined in 1986, my lord, they have lost 2 increments as of now because on 1998 I have been made, my lord, a holder.
Okay, yes, Dr. Mozika, you're saying that this whole thing watered down. I mean, they are avoiding going to a fresh proceeding.
My lord, that is what we are trying, my lord. That is what we are trying.
Yes.
Because the pleading says that, my lord, some rifle resisted this particular benefit and they are still, my lord, not granting it to us.
Yes.
Lord, in fact, I filed a written submission, my lord, where I've highlighted the stand of the respondent.
I understand that in Contempt, my lord, the jurisdiction is very limited. That is why, my lord, I have been referring to this Gauri Shankar's judgment, my lord, that I had given in the earlier compilation. That in such cases where, my lord, the court finds that there is apparent some error in.
See, the only thing is difficult to discern whether there is any contempt and what kind of contempt been made out in these cases. That's the only thing. There's too much of a checkered history. Because for them they stand that the orders have been complied with.
My lord,
and there's no disobedience of the order passed in WPC 56.
Moreover, my lord, over a period of 8 years, more or less, over a period of 8 years since the contempt is pending, my lord. Now, who has, if there is any violation, my lord, who has committed the violation, my lord? Over a period of 8 years, my lord, so Home Secretaries have changed, Directors General have changed, my lord. So many of them are retired, my lord.
I believe, my lord, the matter has not been placed properly before the Home Ministry. Home Ministry initially says that implement this order. Now, while implementing, my lord, Assam Rifle has created this difficulty that in some trades they have given, in some trades they have not given, my lord. Totally disarray, my lord. In fact, the SLP that they have now filed against the division bench order, my lord, in which all other trades are also now to be extended this benefit of the Pay Commission and its recommendation. That also, my lord, I don't know whether it will change the issue or not, but then that should finally, hopefully, my lord, put everything to end as far as the Pay Commission is there in Assam. Because all entire litigations, my lord, relating to Assam based on that.
My lord, Assam is still on 5th Pay Commission. Our 5th, 6th, and 7th, the 8th is due to come, my lord, in 2026, my lord.
Well,
to reconcile all those things, my lord, now that they have
see, the court is concerned with contempt. Now, contempt is whether the point that they have raised was effectively adjudicated in the proceedings.
It was not in the
See, the thing is that it was effectively adjudicated and there were positive directions. Now, the only in that event, then we can see that, no, yes, contempt is made or not. But if we are to go on, I'm not saying conjecture surmises, but on different contingencies.
A fresh hearing on whether
whether that point is adjudicated or not, and whether it will constitute contempt.
And that requires so many affidavits to file, my lord.
That is, I don't know how far it will be successful, Mr. Pathak. This court has grave reservations because if there's some issues which they still seem to be adjudicated also. Now you're seeking implementation of that.
My lord, the SLP, which was filed against the division bench order here, my lord, the SLP, though it is not, the order is only of 2 pages, but then the consideration was of merits also, and all these were rejected, my lord, and it was noted specifically that in normal circumstances for filing this.
I think you'll have to come by your fresh petition. You can, flag all those early orders that is already been decided. You proceed contempt, which is, because there's no clear. There's no clear cut. It's very difficult. Who are you going to pin it on? Number one, and it's very difficult. There's no clear cut kind of material to show that yes, this is the order. This has been violated. We cannot, even whether that point is adjudicated or not. Regarding this ACP, MECP. Whether the upgradation can be set off against MBCB, was it adjudicated in its entirety?
No, that was not, my lord.
Then
we are not on that. We are on the initial benefit only as of now. They say in the course of the writ matters order, they say that we will now amend the recruitment rule.
Yeah, very difficult in contempt. In a contempt jurisdiction to pass a kind of order is very difficult because it's not clear. Because unless this clear cut contempt.
I am only harping on the fact that as of now, my lord.
So take it for granted that your contempts are going to meet, going to give in a decent burial, allowing you to pursue other things later on.
My lord, that I understand.
The file a writ person, I'll not delay, my lord. We'll try to file affidavit. It requires substantive adjudication, my lord. But let them come
this contempt.
No, my lord. If they file a fresh writ person, my lord.
Yes.
Pending this.
So then you can put all your facts in line, because there are many subsequent developments that have come. It's been extended to other trades, in regard to, regeneration, restoration, all those things.
My lord.
And also the subsequent orders that have come from Ministry of Home Affairs. Those also have been taken into consideration.
Subsequent pay commissions also.
Subsequent pay commissions. So if we revert back to fair pay commission now, and we try to, we have to undo the orders that come subsequent, which have, the 6th pay commission have come subsequent to the. So you take a call, either you close this contempt or there's no point in pursuing.
Reorganization of rents, my lord, have not come in the subsequent pay commission. Only pay revisions.
Pay fixations have come.
Rent fixing, that was only in the 5th pay commission where parity was sought to be achieved with Delhi police and all other.
But even parity at some time now it led to recovery after upgradation and the guy's promotion again upgradation. That also created a lot of problems.
Yes. All these things are, my lord.
All these things that there is.
All these things are going wrong, my lord. Therefore, I am asking, my lord, that.
Now, on whose neck will we hang his contempt now? After so much water has gone on the bridge.
My lord, we have not caused any delay, my lord. We have tried to press all material as far as possible, my lord. That is why I have been harping. I know, my lord, in contempt the jurisdiction is limited. Then I pointed out in this kind of cases, my lord, that the confusion has arisen, my lord, out of, my lord, implementation of an order. The respondents can be asked to reconsider, my lord.
We can't, in contempt, we can't ask them to reconsider. That's the whole problem. What I'm saying is that it's so limited jurisdiction, even if they're saying under this blatant, we can't discern from here also. Because that issue which we are seeking also for implementation, that's not been properly adjudicated in the proceedings also.
It's the only thing that I thought my learned friend had also placed before your lordships was that the very plea which is now being sought to be urged before your lordships was urged in the SLP before the Honourable Supreme. And that was dismissed.
Then you have to bring a fresh petition, I think. Because there's too much water under the bridge. Now we are in the 7th pay commission.
7th is going to be over in 26 minutes.
Well, this would essentially result.
Orders then.
Let's maybe just try and
In contempt is very difficult. I've gone through the papers, Mr. Paul. It's become absolutely, unmanageable. And contempt is just whether it's any violation or not. I mean, maybe it's beyond my comprehension, but I cannot.
My lords, we can just try and assist your lordships on just one small issue. The directions passed by this Honourable Court were very specific, my lords, insofar as how it is to be implemented. Now, when they went for implementation, my lords, that's where they deliberately chose to alter a few words here and there, which has led to this entire confusion.
It's substantial for them to say they've complied.
My lords.
You also not complied. Now, to go through that entire.
No, my lords, I can only try and establish before yourself, lordships, because as your lordships have rightly said, once there is at least some kind of compliance, my lords, your lordships would not interfere in the matter. What I'm submitting before your lordships, my lords, that there was no implementation.
See, whatever we'll say, like whatever residual rights you have, and no one can stop you from agitating him again. But it has to come in a proper, agitated
that
process
entire matter
where effective orders can be passed. Here, nothing. The only thing we can say, yes, contempt is there. Now, for them, now we issue orders for initial contempt proceedings. What happens after that? Now, contempt is an allegation, a notice has been given to the court. Now, formal under the High Court rule, we have to initiate contempt proceedings if we say something's made out. Now, even when it comes to that, it'll become another hearing, will take 2 years.
Well,
that is what's going to happen.
My lords, our only hope is, my lords, that once your lordships take cognizance, my lords, of whatever is going on, probably they will go back.
For them also, it's not a question of one person who has committed purportedly. It's a question unraveling the entire, and it will be best served if it's just this court will give a decent burial, just indicating the tentative view.
Well, may I just pray your lordships have this matter on Tuesday? I'll try and get whatever material I can to support whatever I'm placing before your lordships.
Okay, Wednesday.
Wednesday, my lords.
Yes. This is the matter on verse 6.
Right.
18. 18.
Okay. 18, who's there?
On the 18, your lords will see the order sheet, my lord. 13-7, no one appeared. 4-8, no one appeared, my lord. Then 18-8, on the last occasions, Mr. Dev appeared. Today again, it seems.
No, Arang appeared. Who's this?
Ellen Arang, vice.
Contempt against what order?
And this also is pending since 2016, my lord. This contempt also.
No, who are the counsels before then?
Earlier, Mr. Sangreso was appearing, my lord. In 2022, Mr. Sangreso was there. Seeking compliance of order dated 2012. Contempt file in 2016.
What should we do? Where's the order? Did we violate it? Page. This is a single case of contempt, that's fine. Yes.
17th December 2012. This lots will find it. Page 18 of the this one.
Petition.
Of the contempt.
18, sorry. Yes.
Page 18.
When was this contempt petition filed?
2016.
After 4 years?
After 4 years.
What was the reason given for entertaining it?
After this order was passed by the learned single judge, there was an appeal filed by us.
Yes.
Then in 2013, a contempt application was filed, my lord. That was closed in 2015. That order is at page 41.
31.
41.
Yes. 41 is
the order dated 7/7/2015, passed in earlier round of contempt application, my lord.
Yes, so what happened after that?
So, my lord, in my humble submission, my lord, this order, my lord, has totally diluted the order, my lord.
Which order?
This order dated 7/7/2015, my lord. What has been recorded here, my lord?
Yes.
That it is respectfully and humbly submitted that your respondent, after taking the charge as Secretary Home, has acted promptly in complete deference with the directions contained in the said judgment and order of the Honorable Court. The issue of merger, upgradation of posts, and thereafter amendment of RRs need to be considered by DOPT Department of Expenditure, Department of Legal Affairs, Ministry of Law and Justice, and their approvals are necessary for taking decision in the matter. In view of the above, the respondent may kindly be allowed some more time, and the respondent assures this Honorable Court that the matter is being rigorously pursued with DOPT so and so, and based on their views, approval, a final decision will be taken at the earliest. But even in this contempt application, the same problem, my lord, order of 2012, my lord, to pin down what is also said. The fact that contempt application is pending for 7-8 years, my lord.
No, what did he say about this order dated 7/7 in this?
My lord, what we have said, my lord, is.
No, what did he say in the petition, in this contempt application?
In our affidavit, my lord?
No, in this contempt regarding the
delay.
Regarding the delay, yes, regarding delay and regarding the observations in that 7,000, whatever order, 15 or 16. We come to page 8 of the contempt application. Then
dismiss the contempt RTA application, so and
then it comes to see this number 7, para 7 at page 11.
So statement contact injured the petitioner.
That fraud has been committed by you in giving a wrong affidavit before the division bench, before the contempt in the division benches. Umanat order. Where is he? He's been promoted. What's his condition now?
He's retired from service, my lord.
What is the effective directions and the judgment dated 17 December 2012? What is the effective direction?
Page 29, my lord.
Page
29 of the contempt application. The offshoot of the foregoing.
Yes.
Read.
Yes.
The offshoot of the foregoing discussion is that both these writ petitions are allowed. The respondent authorities are directed to amend the Assam Rifles so-and-so recruitment rules to incorporate the changes brought about by the merger of the post of senior accountant with the post of accounts officer, junior accounts officer and record officer positively within 3 months, and thereafter convene within next 2 months a review DPC to consider the promotion of the petitioner to the post of accounts officer in the pre-revised scale of so-and-so by upgrading to the higher grade pay in pay band 2 corresponding to the pre-revised pay scale of so with consequential benefits. The parties are out with the respective courts.
So what happened after that? Was it considered?
But what transpired, my lord, in our affidavit, we will next that.
The contempt between the court and the contemnor, so we can dispose it of in the absence of the. What did you send in the affidavit?
Moreover, my lord, in our affidavit that is filed sometime in November 2019, my lord.
Yes.
The petitioner herein filed another writ petition in 2019, my lord, and we have annexed those orders.
So you say the order stands merged with the later orders passed in the later petitions?
My lord. But if the subsequent order passed by Justice Mir and upheld by Division Bench in 2019, my lord, it totally changes the entire complexion of the direction issued by Justice Vaipai at that point of time. My lord.
The review DPC was never held.
It was never held, my lord.
Where does Justice Mir refer to the 2012 order? In this order dated
16/8/2018. Annexure 1 to this update.
Yes, where does it refer to 2012 order?
In para 9, what should say? Para 6 of the division bench's order, my lord, deals with the same very aspect, my lord, which was para 6 of the division bench's order.
Yes.
Page 9. The appellant was promoted to the post of head assistant on so-and-so, thereafter promoted to the so-and-so on the basis of rules of 2001. According to the appellant, as per the rules of 2001, he was entitled to the promotion as UD in the year 1989. As head assistant with effect from so-and-so. In 97, he was promoted as senior accountant, whereas illegally he was granted promotion as head constable 116. So basically, my lord, what direction was given by Justice Vaipai, my lord? For which
review DPC that whether he was eligible from 1997, that's all.
My lord.
But he was given 2006.
More or less similar prayer in this subsequent writ petition was rejected, my lord, on the ground of delay, my lord.
Yes, heard of the N. None appears for a petitioner. Perusal of the materials on record reflect that the matter pertains to an order stated to be violated in the year 2012. So, subsequently, the writ petitioner again approaches court in the year 2013, which culminated in the appeal number
17 of 2019.
2019. As a matter of great vintage, it is not possible for the court to discern any actionable claim of the petitioner as on any actionable grievance of the petitioner as to violations of orders of this court. According to Contempt, application stands closed.
24.
This is that matter concerning that land custom station, Millets. But Mr. Kinta is not available, Millets. He's shown on leave today.
You ready with the matter?
Lordship, he was supposed to appear through VC, Lordship, but then he had to go to the airport.
Hospital? Had to go to hospital? Airport?
Lordship, he's out of station currently. He's coming back. So he was supposed to appear through VC, Lordship. But then his flight, he had to go catch his flight, Lordship, so he had to go offline.
To go abroad?
No, Lordship, he was out of station, he's coming back.
What to do then?
After 2 weeks.
Yes, as Mr. Vijay Kenta said to have left for the airport. This is matter after 2 weeks. Don't record that here. Due to unavailability of the senior counsel on behalf of HDC, this matter for 2 weeks.
It's already gotten recorded in some other matter.
In other courts.
Court 1.
That's gone to the airport.
Obliged.
Right.
Yes.
Well, as item 25, I'll make a similar prevalence. My friend, Mr. Day is there. What is it regarding? Cancellation of offence.
Yes, this is the last order.
Yes, my lord. That is, there was some
Mr.
mistake.
Vijay, you can't just pick and choose the matters you want
No,
to
no,
review.
it's not like that. My lord, what happened, my lord? I have taken the concern of my friend, senior friend, but that was not communicated properly, my lord. Yes, my lord. I am tendering apology for that, my lord. We have discussed
Jointly.
that.
Yes, that
I'm told, well, your lordship
recorded in 8/8/2023. It appears as submitted by the senior counsel, Mr. K. Paul, and Ms. S. D. For the petitioner and respondent, it's due to some misunderstanding. Stop. And as such, the same is same understanding. So, next paragraph, Mr. K. Paul, seek time
after 2 weeks.
Praise that he made an accommodation. This is matter of 2 weeks as prayed.
I apologize for the inconvenience caused on the last occasion because we were told your lordships had to come back to court.
The court reconvened for the matter.
I have asked my friend.
Please tell these your poor juniors. I mean, like, they were just standing here.
We tender our apologies, unfortunately. Obliged.
Next week, my lord.
Huh?
Next week, I pray for time, lordship.
You already filed?
I pray for time, lordship.
Why? Small matter?
Small matter, lordship.
Then?
Here, the issue is that before the expiry of the term, lordship, PHC, then they have ordered for election without dissolving my committee, lordship.
Okay, on the prayer, Mr. S. Next matter for 1 week.
I filed the affidavit.